Hey, good afternoon and welcome back to docket number 210515 REO1, PURA's investigation into revenue adjustment mechanisms for a performance-based regulation framework. So we're here this afternoon for our 14th technical meeting in this matter. And similar to the prior roundtables that we have been hosting in this docket and others, we will resume the format of facilitation by our wonderful staff here. So I'm going to turn it over to Director Kramer to kick us off here, please.
Thank you, Chairman Gillette. Thank you, Commissioners, and good afternoon, everyone. As the Chairman mentioned, my name is Peter Kramer with Authority staff, and I will start by laying out the plan for our meeting this afternoon. So first, with our objectives, we're here to further develop key potential regulatory reform topics. And particularly today, we intend to discuss the various mechanisms within the multi-year rate plan, as discussed in the revised straw proposal that was issued by the Authority on February 27th. Our second objective is to enable some dialogue among participants to discuss these issues and develop ideas as we continue investigating the PBR framework. Second, our housekeeping items. This meeting is being broadcast live on PURA's YouTube channel, and the recording of the live stream can be found there after the meeting. We're also joined by a court reporter today, and the transcript of the meeting will be posted to the docket, or I'm sorry, to the website when it's available. So for the meeting, please ensure that your microphone is on and speak into the microphone so that both in-person and remote attendees can hear you. And with regard to our roundtable representatives, seated up here at the tables are the identified representatives from docket participants and other stakeholders. And as indicated in the notice of technical meeting, these identified representatives are the main participants in the roundtable discussion today. However, other representatives in attendance may confer with the identified representatives and may be recognized to speak as relevant to the discussion and as time allows. So with regard to conferring, if a roundtable representative would like to confer with a member of the in-person audience, please just step away from the tables. And when your discussion concludes, you can come on back to the tables and join. If a member of the in-person audience would like to be recognized to speak, please approach the podium in the back and be recognized. Then you can speak into the microphone so that both folks in the room and attendees on the live broadcast can hear your comments. Finally, with regard to housekeeping, we are planning for a break in today's meeting at approximately 2:30 in the afternoon, though we will keep that timing flexible just depending on the nature and the timing of the discussion. All right, so for our discussion format, we have several topic areas to cover today, as you can see from the agenda. And the topics are focused on the revised straw proposal and the written comment responses submitted by participants last Wednesday. The topics include the attrition relief mechanism, plan duration and off-ramps, going in rates, the revenue cap formula, including the I, X, S, and Z factors, storm costs, capital funding mechanism, return on equity and performance incentive mechanisms, PIMs, the efficiency carryover mechanism, or ECM, and standard filing requirements and other potential MRP guidance. So it is an ambitious agenda. And we will continue the discussion on these topics as may be needed at technical meeting number 15, which is scheduled for next Monday. For the discussion format for each of these topics, Authority staff will start with questions for participants. And certainly the participants are free to ask questions of one another as well during this time. And I will endeavor to keep our discussion on track so that we can cover as much of the posted agenda as we can. So with that, I think our last step before we get started is introductions. So if we could start with you, Ms. Van Luling, if you can state your name and affiliation, and then we'll move around the room.
Hi, I'm Andrea Van Luling. I'm the controller of networks on behalf of UI.
Jacob Hurwitz, Senior Director of Revenue Requirements at Avangrid, here on behalf of UI.
Jay Goodman. I'm an attorney with the law firm of Couch White LLP, appearing on behalf of the Connecticut Industrial Energy Consumers.
Jeffrey Sear, Utility Workers of America, 470.
Moses Rams on behalf of Utility Workers Union.
Joe Malcarney, IBW Local 420 for the Sisters and Brothers of Eversource.
Albert Zablowski with the OCC.
Tom Wheel with OCC.
Doug Horton, I'm the Vice President of Distribution Rates with Eversource.
Julia Freyer with London Economics. I'm here on behalf of Eversource.
Great. Thank you all for being here. And with that, I did want to just invite our representatives from the unions. I know that we had issued this revised straw proposal about a month ago. We had several written comments submitted into the record. I don't think we saw any from the union. So if you'd like to open with a statement regarding any comments on the straw proposal, please do. Otherwise, we can get into the discussion and get to questions for the unions as we go through the discussion. But I want to give you the opportunity since we didn't have written comments ahead of time.
Thank you for the opportunity, but let's dive in
Okay.
first.
Very good. All right, then with that, I'm going to invite Mr. White with authority staff to get started with some questions for us.
Thank you. So the first question on off-ramps goes to OCC. I'm referring to your comments, page 2. In your comments within your summary table, you mentioned supporting off-ramps with modification. When I read through the comments, I didn't see anything that was quite obvious to me about that. I'm just curious if you could expand on that or add a little bit to it to make it clearer for me.
Sure, this is Tom Wheel with OCC. I'm just pulling up our comments really quick. I don't know that we had particular modifications. It might have been a mistake for us to label that as
Okay. Okay.
support with modifications.
Okay, thank you for that. Another question for OCC on going in rates, depreciation, and I'm referring to Eversource comments on page 23. Eversource states the depreciation study as approved in the rate application would be used to calculate revisions to the historical test year depreciation expense in setting going in rates. This updated historical test year depreciation expense would then be used as the baseline expense adjusted for the annual inflation factor. Does OCC have any thoughts on this?
I think that makes sense to me. I mean, that as I understand that comment, that reflects the way that depreciation is currently set for in a rate case for the rate year. Because if you don't update the depreciation, as I think most people in this room are aware, the depreciation rate itself is a subject of controversy in a rate case that a company often seeks, not often, but not always, seeks adjustment to the depreciation rate that was most recently applied, like in the last rate case. And other parties and interveners often, have differing perspectives on what the appropriate depreciation rate should be. But at the end of the day, it's common for PURA to adjust
the applicable depreciation based on the evidence of the record before it in a rate case, and then that is applied to the, future rate year depreciation rate. So I guess that would be the one kind of, I'm not sure that Eversource necessarily intended to suggest this, but if the intention is that the depreciation rate has to be evaluated in every rate case, I'm not sure I would necessarily agree with that. Although if we are going on a 4 or 5 year multi-year rate plan structure, that might make sense, only because what you're evaluating in the case of what you're evaluating when you're looking at depreciation is sort of what makes sense looking at the assets that are in service at the time of the rate case. And in terms of adjusting it, that reflects our understanding of what the straw proposal is proposing, is that depreciation, once set, whatever the depreciation expense would be for the going in rates would be subject to the I minus X.
Just any other comments if anybody has?
Just a few, just to clarify, I think Attorney Wheel has it generally right in terms of what we were pointing out with our comments, which is that based on the straw proposal seemed to indicate to us that depreciation expense would be set based on a historical period. And also it required there to be a depreciation study. So those two things do seem technically in conflict with one another, where generally you do a study, you use that study to determine depreciation rates, which are then used in setting going in rates. So not that it's completely divorced with the historical level of depreciation expense, but it is, in a way it is divorced because you're taking the plant at a certain point in time and applying new depreciation rates. So we're strongly in favor of doing a depreciation study and having depreciation rates be established as part of a rate case, and then having that be the basis upon which cast-off rates are set so that you get the level of depreciation expense fully informed by the study, not based on some historical period adjusted for inflation or otherwise. And then in terms of the timing of how frequently you do that study, our read of the straw proposal was that it requires a study to be done with every rate case, which I think I agree with Attorney Wheel. If you're doing a rate case on a set cycle of every 4 years or every 5 years, it does make sense to refresh those studies. But there's also a world contemplated in the straw proposal where you're not having a rate case. You're having rate cases more frequently if the utility doesn't stay out of a rate case. And then it may not be always appropriate to redo a study, whether it's a depreciation study, an allocated cost of service study, or otherwise. You might be able to rely upon the most recently completed study if it was just 1 or 2 years previously.
Okay. And I think your comments before mentioned that could have a technical update for a depreciation study that's happened maybe a couple of years before.
Correct. It might be a modified or an abbreviated study as opposed to a full depreciation study that just the cost may not justify to undertake. But we view that as more of a case-by-case basis. Really depends on how frequent or soon in time was the most recent case.
Thank you. Any other comments from any? So I'll start with UI here. Going in rates, end of the evidentiary record. I'm referring to OCC's comments, page 5. OCC stated, we recommend that the authority even more specifically identify the procedural touch point that will be defined as the end of the evidentiary record. End quote. They elaborated by suggesting the final day to submit LFEs as the end of the evidentiary record, which I think was using a prior rate case was 6 days prior to, it moved the date forward 6 days. So just wondering if you have comment on that.
I think the technical end of the evidentiary record is a legal matter, and I'm not a lawyer, so I don't know that I could opine on that. I would say, based on our experience litigating rate cases in Connecticut in the very recent past, the 9-month guideline reflected in the revised straw proposal, I know that's called conservative, but conservative from whose perspective? In our view, 9 months is likely to be longer than the evidentiary record would remain open based on our experience recently completing litigated rate cases in Connecticut. I think the time period is closer to 6 months. You look at something like the CNG and SCG rate case, which subject to check. I want to say we filed in October. Our close of the evidentiary record was in the April to May timeframe, so closer to 6 months than 9. Whether that aligns with a date that is when the last late file is due or the last day that is the technical last day that evidence could be submitted into the record, I'm not sure. But I would say that when we updated certain exhibits that we filed in the CNG and SCG rate case docket 231102, we reflected plant information that was, in our view, through the close of the evidentiary record. And while there was certainly some debate as to the appropriate approach to plan and service in that proceeding, I don't recall whether, we had captured the end of the evidentiary record appropriately being one of those debates. So a little bit of a rambling answer, but I may give insight as to where we're coming from.
Eversource, anyone else have any comments?
I think, well, I'm with Mr. Hurwitz in terms of like whether it's 6 days after a certain date or whatever is splitting hairs. I think our substantive feedback with regard to establishing going in rates continues to be what it was at the start of the case and through the prior 13 of these tech sessions. In the realm of we should be setting rates that are, the going in rates should be set to reflect a reasonable expectation of what the utility's cost of service in the rate year would be. So less to do with when the evidentiary record in the rate case closes, but more to do how the rate year rates are set for changes that may occur after the close of the evidentiary record. And I would say generally our posture is and has been that whatever the component of the cost of service, once we're making a known and measurable change, and I think here, what I was reading the straw proposal to try to do is to say, in certain cases, inflation might be sufficient for that known and measurable standard. If we're gonna apply inflation, or we're gonna apply a known and measurable change, whatever the change is that we're applying, it should be designed to get us to the rate year, whether it's up or down. In the straw proposal had cutoffs to say changes will not be made after a certain point in time. And that's still insufficient because it's still getting you either, I think in some cases it said to the start or to the close of the evidentiary record, meaning any change thereafter wouldn't be incorporated into the going in rates. Or it said a change that would take you up to the start of the rate year and would similarly be deficient because it wouldn't be getting you to the expected cost of service in the rate year. And so fundamentally, and as a foundational principle, I continue to believe that any framework we're establishing or PURA is establishing should be and has to be designed to get to an expected level of cost of service in the rate year. Establishing a cutoff prior to that, again, could cut in either direction, but will be designed to not get you to your expected cost of service in the rate year, but something earlier than that, and I think that's a flaw.
Thank you.
Sure.
Anyone else?
To just make a similar point a different way, although if someone else was going to go first, I didn't mean to cut them off. I think most of the parties to this proceeding have agreed that our intention is to set rates that reflect the utility's cost of service in the rate year. And if we're designing a formula that changes the approved cost of service based on, a legal technicality, it doesn't strike me how that formula could possibly reflect the company's actual cost of service in the rate year. Said differently, if we're trying to measure the company's cost of service in the rate year, why does that change if we spend 6 months versus 9 months litigating a rate case?
Oh,
Thanks. I would just add, I think from our perspective, whatever the date of the close of the evidentiary record is, it should happen before the start of the rate year. So that going into the rate year with going in rates, there's certainty as to what the rates in at least rate year 1 will be, as opposed to an opportunity to further adjust the going in rates for rate year 1 during the rate year, which I think could cause confusion and lack of transparency for customers. And also, it would really undermine the idea of rate certainty, which is one of the benefits of multi-year rate plans from our perspective.
Attorney Wheel, did you want to comment?
Sure. It's probably already clear from what our comments say, but just to maybe clarify for anyone who didn't take a look at them, what we were getting at there was that if we're going to, like if assuming that we're using the close of the evidentiary record as like a concept for the close of plant, the date that makes the most sense for us is the last date by which evidence can be filed in a rate case that can be subject to cross-examination. That's why we picked the late file date. And I acknowledge that like when you're talking about plant, a 6-day gap is meaningless, particularly like that plant is often at the average overall plant in a month. So like that 6-day gap is probably not even accounted for in the number in most circumstances, but it's just sort of the practical matter of everyone should have an opportunity to take a look at what's being filed in the rate case and ask questions about it, which if we use the close of the evidentiary record, as has been said in previous rate cases, is like literally the last day of a hearing. Like the close of the evidentiary record would be like the last minute that a hearing is over, meaning something that's filed at that time would never be subject to cross. So that was our rationale for picking that particular point in time.
Thank you. I'm going to move on to the revenue cap formula.
Actually, Mr. White, just one, before we move on to the revenue cap formula, I did want to just check and see, I know we've been breezing through topics here, but if there was anything else related to going in rates that any of the parties wanted to raise and flag for discussion here today. And we are taking, this approach to go through the questions because we have had we see the written comments, we've read them, reviewed them, and want to make sure that we're getting to some of the particular topics within the each of these discussions or each of these items that need some further discussion and evolution here. So anything else related to going in rates at the moment that folks wanted to flag or raise?
I'll just very briefly emphasize the 2 of the 3 major concerns in our written comments that related to going in rates. I know you've read them, but just to briefly recap. 1, the approach to cutting off plant as of a historical date and time. As we've described in several sets of written comments past and reiterated in this most recent one, that really undermines the utility's opportunity to earn its authorized rate of return if the vision is the utility invests at the level consistent with integrated distribution system planning and whatever coincident emergent needs occur. The rate structure set in this revised straw proposal, while certainly an improvement from the original straw proposal, and we're thankful for the consideration to the written comments to date, it's still not going to position the utility to earn its authorized ROE if it invests at that level because of the approach to plan and service. And then similarly, as Mr. Horton described a minute ago, we think the approach to inflation and only allowing known and measurable adjustments to the beginning of the rate year likewise will work to effectively prohibit the utility from earning its authorized rate of return. And we see these as significant challenges to the success of PBR.
Thank you, Mr. Hurwitz. Any other comments related to going in rates? Okay. All right. Thank you, Mr. Go ahead.
Thank you. So moving on to the revenue cap formula. I have a question for Eversource. It's probably for London Economics. So on the S factor, if S factor values are determined in a rate case as informed by a benchmarking study, are there industry guidelines, best practices that exist for an S factor?
Thank you for the question. I think there are well-known, I would say, technical guidelines on how to do high-quality benchmarking studies that would be really useful to consider. The S factor itself has features of it that is going to be informed by the detailed quantitative evidence of the benchmarking study, but also should be informed I think by looking at the entirety of the other elements of the attrition relief, the revenue cap and the ARM. So in many cases, what we've seen in other jurisdictions, when the S factor is established, it's done also in light of what decisions are taken on the other component, the X factor, the TFP study, the cycle, whether that's a first generation form of PBR or there are multiple generations of PBR, and also considerations of the future, the differences between the future period and the historical data that underpins both the benchmarking study and a TFP study to determine the S factor and X factor respectively. Going back to benchmarking itself, I think there are a number of different techniques that are used for benchmarking. And I would say that it's very important to have good quality data for the benchmarking and to fit the techniques to that good quality data. Some techniques won't allow you to do as much to think about external factors and business drivers, and that needs to be considered when you're looking at the results of the benchmarking study.
Wondering if anyone else has any comments? Moving on to the Z factor, question for OCC. Referring to your comments on page 12, OCC stated that any provisions in the PBR framework specifying when and by what procedures deferred expenses should be allowed should be carefully specified. Keeping in mind that Eversource described their proposal for a Z factor as being highly uncommon, does OCC recommend that the PBR framework make such specifications? If so, does OCC have any specific recommendations?
Where we were coming from with that comment was just the idea, and I think we did kind of throw in some ideas for kind of what to define, like how to define exogenous. Maybe it's at the bottom of page 11, where we talk about costs, for example, should shown to be outside of rate base, been prudently incurred, haven't been addressed in any other existing rates or sources of cost recovery, and be material. So the idea was just that it would be helpful to kind of have, even if the Z factor is not used very often, to have kind of an idea ahead of time of what kinds of costs qualify for Z factor treatment. Because ultimately what it comes down to is that even under the PBR framework, maybe even especially under the PBR framework, base rates are supposed to continue to include some level of risk for the company in the form of, if there's a deviation from the allowed revenue and actual costs to some, like we talked about many times in this room, the idea is to set the revenue requirement with the closest, best idea of what the actual cost will be in the future. And if there are deviations from that one way or the other, that's where the risk lives. So we see the Z factor, just like we see deferred accounting now, as an exception to that rule, because it's pulling things out of that risk altogether and essentially allowing for reconciliation of actual. It's introducing reality back into the world of rate making. So all we were trying to communicate was that should be truly exceptional, and there should be kind of clear guidelines for at what point do you get to do that, and at what point is it inappropriate. So there should be a clear kind of division between what's still needs to be subject to the risk of the regular revenue requirement and ARM versus what can be allowed Z factor treatment.
A follow-up to Eversource on that. If I recall correctly from what's already on the record, Massachusetts gave an example of a well-defined specifications for a Z factor.
Yes.
Okay.
Yeah.
Yeah.
And I don't disagree with anything Attorney Wheel said in terms of that if an exogenous event should be limited and not expected to happen. So there should be a high bar to clear in my mind to demonstrate that it's outside the norm. There would need to be a triggering event as opposed to just like an underlying change in cost for whatever reason. And then that cost would need to be of a level of significance to warrant special treatment outside of the normal course. So I don't disagree with anything Attorney Wheel said in that regard.
Thank you.
Just as a follow-up then, I'm sorry, is it the case, Attorney Wheel, that OCC is looking for additional clarity as to what exactly would qualify, or am I misunderstanding?
I think I need to review what's in the straw proposal in terms of
Okay.
specificity. But I think what we are looking for is a standard. I think it's hard to set one. I mean, like, ideally, we'd have a standard for instance, materiality that's clear and finalized. But again, it's hard to know. It's with the understanding that it's hard to like set an exact kind of line in the sand between what's material and what isn't, because I think it kind of depends on what the thing is that has occurred. So I don't recall whether we had issues with the level of specificity in the straw proposal, but what I do know is that we were advocating that the final decision in this docket ideally will make very clear what qualifies for Z factor treatment and what doesn't.
Okay. Potential, so what's included in the revised straw proposal with regard to the Z factor, it's a materiality threshold and some guiding criteria. Would, I guess for any party here, is that sufficient clarity, or is there additional specificity needed, such as an exhaustive list, or even further specificity to create that sort of channel that exogenous costs could go through?
I mean, I can start. I think that generally, I thought that the straw proposal in terms of the criteria and the definition of the threshold were sufficient. We don't agree with the size of the threshold. And we take strong exception to lumping in storm costs. I know it's a separate agenda item, but that should be looked at separately from just an exogenous type of a threshold, where exogenous is something that we don't expect to happen, which is why I would caution against getting too overly prescriptive. I think it needs to be a high bar to clear, but the circumstances should, allow for some flexibility. We just don't know what would be exogenous, whereas storm costs, we certainly know we're going to have storms and need to respond, and they're going to be a recurring theme. So I think those are generally our comments is in relation to the exogenous events.
Thank you.
I don't think we at UI had significant issue with the criteria either, again, bifurcating storm costs from that comment. And I think in this most recent set of written comments, we in fact encouraged changing the materiality threshold to the materiality guideline. And what we were thinking of as we recommended that is we went back and studied some of the recent regulatory assets and liabilities that have been approved for UI based on an understanding that's similar to what Attorney Wheel described earlier, that this is tantamount to regulatory asset and liability treatment. And some of the examples that we saw were the COVID deferral and increase in uncollectibles following a shut-off moratoria in 2021. We saw a change in pension accounting rules back in 2017 and a potential double recovery of GET taxes through UI's conservation adjustment mechanism in 2020. And also, of course, I think we all heard the property tax example from Massachusetts earlier. It struck us as we were developing these written comments that once that triggering event happens, you're not going to know with perfect certainty what the magnitude of that event is. For example, our pension deferral, the exact amount we defer depended on the passage of time, or the change in the property tax rule. If you're sitting there when that Supreme Court decision in Massachusetts happened way back in 2011 or 2012, you're not going to know exactly how that will be effectuated by the towns, or our CAM GET deferral depends on the amount of kilowatt hours that we sell. And so it struck us that it'd be difficult to make a determination that, like, yes, this thing is going to pass the threshold at the time the triggering event happens. And further, there might be times where you want to use Z-factor treatment, even though you might technically miss this deferral threshold. And I say that thinking of the CAM GET example. That's a deferral in which UI owed customers money. And I think if you do the basic comparison of the amount approved relative to the revenue requirement, it would have failed the test. And it strikes us that we don't want to be in a position where the company is required to hold on to that money because of some strictly imposed test designed before that circumstance was even contemplated. So that's a long-winded way of saying we didn't have a lot of feedback on the criteria, but we did propose changing a materiality threshold to a materiality guideline.
Thank you for that, Mr. Hurwitz. Appreciate that. Any other comments related to the Z factor and the materiality or the criteria proposed in the revised draw?
Hi, Tom Wheel from OCC again. I guess one thing that just comes to mind after listening to Mr. Hurwitz is my understanding of the structure of the Z factor as described in the straw proposal is that it would be similar to the way we do a deferred accounting now, meaning that there'd be an initial indication from PURA that a company would be permitted to kind of book a particular expense separately and then come back to later to seek recovery of that expense. And when they come back later, as it works now, it's really primarily a prudence evaluation of whether the costs that were permitted to be booked separately were prudently incurred. But I wonder whether, given that there are sometimes circumstances where it's not clear whether a cost is material, whether all four of these standards should be reviewed at the front end and the back end. And I'm not sure whether prudence is on this list of the four kind of criteria, but maybe at the end, when the costs have been incurred and the company returns to seek recovery, there should be a second review to determine, did this turn out to be material? Did it turn out to be for sure outside of what's already recovered in rates? That's just a thought that occurred to me in the moment.
Right, thank you.
Thank you. Continuing with the Z factor question for OCC. OCC stated that it agrees with the proposal that deferrals included in the Z factor and the cost of capital should be treated as a separate category under the revenue cap formula and not multiplied by the IX or S factors. I'm hoping you can elaborate on what you meant in relation to the cost of capital in that statement. If you were looking for it, it's in your comments, page 9. I'm sorry about that.
Sure. Well, I think it's my understanding, my pause was I just wanted to make sure I wasn't misunderstanding what's in the straw proposal with respect to the cost of capital. It's my understanding that the cost of capital is going to be calculated, like there's an approved percentage rate, like the weighted average cost of capital, and that's approved just like it is now in the going in rates, in the rate case kind of preceding the going in rates. It's our understanding that in, for instance, rate year 2, the cost of capital is going to be set using the pre-approved weighted average cost of capital multiplied by the authorized level of rate base in that year, as opposed to being pre-baked into the overall revenue requirement and just subject to the I minus X. But I'm realizing now maybe we were misunderstanding. Maybe the revised draw proposal doesn't say that. I guess another way of saying that is if there is incremental plant, for instance, or any incremental rate base. So you have rate base set for going in rates for rate year 1, you set the cost of capital revenue requirement by multiplying your authorized weighted average cost of capital against that authorized rate base. If you're not authorizing any incremental rate base, I guess from that point, it would make sense to just apply the whole revenue requirement to the by I minus X. But I think what we are thinking is that the cost of capital associated with anything that's coming through the CT bar or a tracker or anything else that affects rate base on a moving forward basis would be the weighted average cost of capital multiplied by that rate base effect. But again, maybe we're misunderstanding what the straw proposal says.
Thank you. Question, I'll start with UI on the Z factor. Does a reg asset or reg liability only get created if the Z factor threshold kicks in?
I mean, there was some extended discussion of when exactly a regulatory asset or liability gets created in docket number 220808, which UI took some significant issue with. And I understand the record in this proceeding includes the accounting opinion of Sean Riley prepared on behalf of Eversource on this topic. And our position is that a regulatory asset or liability gets created when we incur the cost associated with that thing. And that's when carrying costs should begin to be calculated, because that's when the utility has to outlay the capital, or conversely, benefits from customers providing the capital to it for that underlying thing. So in our view, the regulatory asset or liability gets created when the cost is incurred, or when the utility benefits from not incurring a cost, whatever the circumstance may be. And accordingly, the calculation of carrying costs should be synchronized with that date. When that balance gets recovered from customers is a different matter, but that would be our position. And if there's an aspect you were getting at with your question that I just missed, I'd be happy to take another shot.
There wasn't. Thank you.
And the only thing I would add is that it's when the cost is incurred and when it's determined that it's probable of recovery or refund to customers, that's when you account for a regulatory asset or a regulatory liability. So as we're incurring the cost, if we have an expectation that it's probable that we can recover that cost in the future under the rules that have been established, we would set up a regulatory asset, or if it's a payment to customers, a regulatory liability.
Thank you. Anyone else? Moving on to within the revenue cap formula, but moving on to growth, customer load growth. Question for Eversource. Referring to your comments, pages 9 to 10, Eversource states the proposed revenue cap formula does not align with the projected load growth in New England, particularly in Connecticut. A few sentences later, a revenue cap framework does not allow the revenues to increase with new customers and growth in demand from existing customers. It also does not allow funding for the increased capital and operating costs of serving new customers and additional load. Could you describe the projected load growth in Connecticut? Just briefly. I know there's a visualization in there, but I just, in words.
In terms of, I think the drivers that are considered, the comments for Eversource incorporate facts and figures that ISO New England has put together as part of its regional plans. So drivers for additional electricity load come from electrification, come from integration of behind the meter distributed energy resources, come from broader decarbonization goals, electric vehicle integration. So those are the factors that are behind the forecasted amounts that are presented for Connecticut, and I believe page 13 and 15.
Okay.
The comments.
And then another, continuing with a question for you. I'm not sure if anyone else had any comments on that, sorry. Continuing, regarding capital costs, does the company's IDSP account for new customers, existing customers, demand growth, and the related funding needs?
I can take that, and I think it's a good point. I think it's unclear because that's still happening in parallel. So our point is, as it's designed in this track on the REO1 side of things, where we're setting a revenue cap or a formula that's going to have a target for revenue decoupling, and we've identified some concerns with the CT bar and other aspects that's within this framework. It's unclear how that's going to align with the IDSP. But if the thought is that the IDSP or the REO3 framework, we'd have a process to go through where, you know, a decision is made on that IDSP, and that capital forecast does include or account for changes in customer growth or customer usage in demand. Then as long as those changes are reflected adequately in REO1, then I think the pieces would work together. But as we're sitting here looking just at REO1 in isolation and seeing the concerns that we have with some key elements of this proceeding and not knowing how the two are going to actually link up with one another, then structurally and as it's designed here, this REO1 framework doesn't explicitly contemplate growth in customers or demand, which are two major drivers of costs on the system.
Thank you.
Sure.
And a follow-up question regarding operating costs. Could the company account for new customers, existing customers, demand growth, and the related funding needs via known and measurable costs?
I think, well, I guess the answer is yes, to some extent. Again, getting back to my earlier comments, though, around what does PURA view as a known and measurable cost and how will we ever meet that burden? But also that would only take us into account for rate year one. The structure thereafter would need to be taken care of as part of the PBR framework, which, again, if the application of the combination of I minus X is taking into account growth in customers or usage by customer, we would be covered there. But at this point in time, again, it's premature to know or to tell, and it's premature to know or to tell how that IDSP REO3 framework would correlate over here. So I think broadly, our point was simply that as a utility, number of customers and customer usage and demand by those customers is broadly what drives our costs. And so we need to make sure that whatever the framework is, takes into account actual changes in number of customers and demand put on the system by those customers. Otherwise, we would have a natural misalignment with our cost structure and whatever the rate-making framework is.
Thank you. Anyone else?
I guess just,
I think Tom was.
oh, sorry. Attorney Whale, please.
Sure. Tom Wheel again. I think we agree in principle that it's not clear. It's hard to tell like how to account for these future costs with expanding growth without knowing like how the whole picture works together, which is, I mean, we see it from a slightly different angle. That's why I don't know if we're going to get more into this later in this discussion, but that's the basis for our concern about the CT bar, how that interacts with the X factor and potentially a capital tracking mechanism. Like we're concerned about the number of different mechanisms that potentially account for the same thing, which is ultimately like incremental investment, the necessity for incremental investment, and the notion of including growth as potentially what seems like a fourth kind of indicator. That we have concerns with that, but it's not. But our concerns, I think, are similar to what Mr. Horton was just talking about. Is the concern is we just don't really understand how it's all going to work together. The angle we see it from is we're concerned about double recovery or specifically the kind of crossover between these two things. Like my understanding, my rudimentary just a lawyer understanding of the way that like a TFP study works is that it very much accounts for like industry-wide necessity for capital investment. So if that's already accounted for as an adjustment to inflation, then doesn't the CT bar also account for some degree of that? And also wouldn't a capital tracker, and if you're adding in, overall customer growth into one of those elements, that's our concern, is sort of like, how can we be sure that we're not kind of creating these zones where these things intersect, where we're ultimately double paying for the cost of incremental capital investment?
Thank you for that, Attorney Wheel. And I think that we certainly are going to get more into the CT bar discussion on the agenda today. And it relates to the point you make there. It relates to a question for Eversource on the growth piece, where we may not have perfect certainty of how it all interacts in a rate case when implemented at this point in time, but as written in the revised straw proposal and using an integrated distribution system plan to as a basis or a starting point for a capital funding mechanism, would it not be the case that that integrated distribution system plan is based on the forecast, which includes growth from customers, growth from new customers, from existing customers increasing their demand? So I guess I'm still a little confused how even the revised straw proposal doesn't account for growth if it's basing capital funding through the CT bar on the integrated distribution system plan.
I would agree, Mr. Kramer, yes, that based on the straw proposal, if the IDSP is going to include our capital forecast as best as they're known at the time of the IDSP around customer growth and changes in usage per customer or demand on the system, and then that capital is reflected in this REO1 framework, I don't disagree that there's a structural problem. It's just that the structural problems that do exist in this framework and the uncertainty around how that IDS process will work is what's caused us to just want to kind of put a stake in the ground to make the point that whatever the reality is or whatever the framework is, it has to take into account customer growth. And when you have, because of the costs that puts onto the utility, and when you have revenue decoupling, there's no natural revenue support that comes from that customer growth or increased usage per customer or demand per customer. There's no recognition of that. So it was just simply our point to want to make sure to make it known that that's a significant driver of cost for the utility and needs to be accounted for in some way substantially.
Okay. So therefore then it could either be accounted for in the use of the integrated distribution system plan as a part of the capital funding mechanism, or if that were not the case, the company is advocating for some other way to account for growth. Is that
correct?
Okay.
And I think Ms. Freyer can speak to how, within a PBR framework, how you would structurally do that with yet another letter in the alphabet soup, that you'd add into the mix. But there are ways that you can accommodate it if it's not taken care of in other ways. And I also agree with, again, the sentiment that Attorney Wheel raised is the more letters we add, the more complicated it becomes and the more difficult it then becomes to parse out, where are these things covered? And I totally agree with that sentiment. It's just still fundamentally for the utility to be able to operate and to deliver any of the benefits of PBR for our customers, we need to have these things covered in some way or another. And all three of these reopeners, which are happening in separate tracks, need to work hand in glove and be cohesive, or we won't be able to achieve that result.
Thank you.
I just wanted to jump in on one technical kind of refinement. Attorney Wheel had mentioned that a TFP study should capture some of the growth, but I wanted to just make sure we were on the same page. A TFP study, which will set the X factor, is historical or backward looking. So it will capture growth that's historically present. And to the extent that future growth, which drives cost, is very different than the historical period, that isn't going to be present. And so that is one of the reasons we had those charts we put in there that had a very long historical period, as well as the ISO New England's forecast going forward. At least from the work being done right now at a regional level, it does look very, very different, that some of the future growth is not necessarily going to already be embodied in the TFP study.
Sorry, Tom Wheel again. I think I'm happy to say I did understand that part. Feel very proud of myself for wrapping my head around this X factor thing. I was making a more kind of rudimentary point, which is sort of like, at least the way I understand it is, you know, if you start from the baseline suggestion that like, well, why don't we take the whole revenue requirement and just apply inflation to it? Why isn't that good enough? And I'm not suggesting that it should be good enough, because you have to account for incremental capital costs. But if you're also already accounting for, well, even historically, you know, like there may be a rationale in the case of a state that determines a negative X, a driver of that may be within the TFP study to determine, well, the capital necessities of the utility industry exceed the rate of inflation. So to some degree, you're already accounting for that incremental necessity above and beyond inflation there. And then you're also going to be accounting for it in incremental capital funding. So that's just, I was just putting that out there, that's kind of why we get worried about if you have 4 different mechanisms to adjust the revenue requirement beyond inflation to account for things like customer count and load growth, which both are primarily driving capital costs. It's just, we just get nervous about it. I also did want to say, circling back, Mr. Kramer, you asked, or maybe Mr. White, you asked about a reference we made in our comments to separating the cost of capital from the I-X. I found what I meant to reference, which is on page 37 of the straw proposal. It is with respect to the CT bar. It's the last sentence of section 6 there, which says the revenue requirement shall not include any return on investment, i.e. weighted average cost of capital on the incremental CT bar plant additions. So that was the reference we were making in our comment there.
Thank you, Attorney Wheel. All right, then I think unless CIEC, any representatives from the union or UI want to comment further on the idea of growth that has taken us in a few directions. Okay. Then Mr. White, I think we can proceed.
Thank you. Moving on to storm costs. A question for UI related to materiality. The company stated, UI stated, it is not appropriate to reset the major storm threshold outside of rate case. ... Accordingly, the increase in the major storm threshold must be synchronized with an increase in minor storm funding, which can only occur if the threshold is revised in a rate case. Why would it be inappropriate to reset a threshold for a major storm outside the rate case when the rate case is increasing the revenue requirements each year using the revenue cap formula?
Because an increase in the major storm threshold means that more storms are now going to count as minor storms. And so if the expectation is that the company funds those costs with the amount, the rate allowance it received for minor storms in its rate case, if you increase the threshold for a major storm but don't change the amount of minor storm funding, you have foisted new costs upon the utility without any mechanism to recoup them, which appears to us to stand in contravention to a variety of things, including Connecticut statutes, longstanding rate-making principles, and a host of other things. In UI's recently filed rate case, we demonstrated this exact point by calculating how much UI's minor storm rate allowance should increase because of the increase in the major storm threshold that has already been put upon UI related to the Handy Whitman Index. So we think increasing the threshold without considering the corresponding increase in minor storm costs will, for no reason, require the utility to bear costs inappropriately.
Thank you. Anyone?
One follow-up to that would then, would the minor storm costs not, I mean, if they're included in the revenue requirement, then they're subject to the revenue cap formula. And so therefore, there would be an increase in funding or funds available based on the revenue cap formula. Is it the company's position that that is insufficient? And if so, why? Or could you just elaborate a little more on that?
Only if you did those two things simultaneously. I think your question sort of presupposes that you reset the minor storm threshold at that same time the major storm threshold is raised. What we're saying is, UI is in for a rate case, but not a PBR rate case. If you were to, outside the context of a rate case, increase the major storm threshold, now in theory and in reality, we're going to get less rate relief through the storm deferral, the same exact amount of rate relief through the amount of minor storm cost funding reflected in our base distribution rates. By changing the threshold, you mean now we get less rate relief through the storm threshold, but the exact same amount of rate relief for the minor storm costs embedded in base rates. I think your question, if you're getting at something I'm failing to understand, please feel free to set me straight. But your question, I think, sort of presumes that the threshold is reset in a rate case, and you could do those two things in concert. But what we're saying is by bifurcating them, you have foisted costs upon the utility unfairly.
And I understand, I think, and if I do understand, then is that issue mitigated if in a PBR rate case, that is the time at which a storm threshold is adjusted?
Yeah, considering both issues at the same time would help mitigate this concern.
Thank you. Please.
Thank you. Just following on that. So kind of going down just logically, would it also be inappropriate to recover storm costs outside of a rate case?
Full stop. Recover storm costs outside of a rate case. I don't know that I see those two as intrinsically linked. I think as we've advocated in at least these most recent written comments and potentially prior ones too, although I'm not recalling discreetly, you could recover major storm costs that were deferred by the utility and had their prudence reviewed by PURA, OCC, and others on a more regular basis. And I think that's one of the refinements to this revised straw proposal that we proposed, but that has more to do with the recovery of major storm costs that were already deferred, not sort of changing the rules of the game for what counts as a major versus minor storm cost. Does that answer what you're getting at, or am I missing what you're?
I'm following.
Thank you.
And if I could just chime in to Mr. Hurwitz's comments, I completely agree. The whole idea of storm cost recovery is to set a level of representative costs and base rates, and that's true for storms, but it's for every cost that we would incur. And so in a rate case, the goal is to set a level of overall cost so the utility has that opportunity, but not a guarantee to recover its costs. So if you're establishing a threshold for major storm costs, those would be costs for qualifying events that aren't expensed when they're incurred, but they've reached a level of materiality that they're dealt with separately. It's like we were talking about the exogenous event. These are for random occurrences that can't be predicted. That's material and would have a material impact on customers or the company. That's not what a storm cost is. We know there are going to be storms. We just don't know, no one does, how we could ever set a representative level for storm costs in base rates that wouldn't either harm customers or benefit them, because we're going to get it wrong. So we set a level for the storm cost threshold that says when this type of an event of this magnitude happens, we're going to treat it separately, not in base rates, not in the cost of service, which means that anything below that level, now our goal in the rate case has to be to set a representative level. So the higher you make that threshold, and this was the crux of our comments on the storm cost, the greater you make that storm cost threshold, the more you have to put into base rates in order to capture anything below that amount at a representative level. And you could end up, and we showed just with our recent experience over the last 4 years, it would require just on its own a $76 million increase in the level of base rates if you set the catastrophic storm threshold at 1% of total revenues. It would require a significant increase in base rates so that amounts below that, which are now just going to be subject to traditional accounting, can be dealt with through the normal course. Commissioner, to your question on storm cost recovery outside of a rate case, I absolutely think it can, and obviously we've made a similar proposal in our RAM proceeding that the rates, when we're talking about storm replenishment or storm cost recovery, does not need to be tied to a rate case, because we're not talking about the representative level of storm costs that are incurred in any given year. We're really talking about the amounts that have exceeded that threshold, whatever it is, and having customers pay for that in the most equitable way possible by avoiding mitigating rate impacts on customers that's going to result as a part of a rate case when all costs of service are updated, and mitigating the carrying charge impact of that balance when it's ultimately set into rates. And not to speak for the Attorney Wheel, of course, but I think the OCC's comments were similar in that given the rising costs of storms and their frequency, having a mechanism that doesn't, by design, have to wait until the next rate case cycle when the rate change would occur with all other rate changes has appeal to customers by mitigating the rate shock of having those catastrophic storm costs, once deemed prudent, paid for in a way that's more gradual over time, instead of building up large unrecovered balances and then going in all at once when other costs are changing too. And that was our major concern with the storm threshold as it was designed in the straw proposal. It would result in a significant increase in base rates. It would have to, or you would end up, as Mr. Hurwitz said, trapping costs. And it would cause all of the negative consequences that I said in terms of, having rate changes, if not dealt with more frequently, just continue to pile up. And we think it's time that we look at a different mechanism, like what we have in Massachusetts and in New Hampshire, just in our service territory. There's a lot of precedent in our neighboring states to look at storm costs and try to come up with a way to pay for them that's, recognizing the growing balances and their frequency of storms.
Thank you, Mr. Horton. And I think the comment you made, I think the OCC had, in your written comments, similarly suggested a more frequent review of storm costs. And on that point, to look at storm costs between the proposed 4-year multi-year rate plans, how, Attorney Wheel, to start with you, how does that separate review of storm costs, how would that avoid, if at all, if it can avoid a single issue rate making problem?
Sure. I mean, I recognize that we, in a previous hearing, brought up storm costs being potentially being part of the Z factor. And I get that that's not happening. I get everyone has concerns with that, but I just added that as a caveat to say, conceptually, in my mind, there is no difference between in terms of like accounting, that what you're doing is, like I said before, you're separating out, we're all collectively deciding like, well, this is a cost that wasn't possible to reasonably anticipate in base rates. So we're removing the positive risk components of essentially out of fairness. Like, it's just not fair to decide, well, there's a $700 million storm or something nightmarish like that, but like, and that's that degree above what's allowed in base rates. We're setting some threshold where we're deciding that the company can be relieved of its obligation to incur risk in order to be fair, essentially. So to get to your single issue rate making question, I think single issue rate making is a problem when you're adjusting base rate components, when you're opening up the whole revenue requirement and making little tweaks, presumably often to try to make them more realistically reflect reality. That you shouldn't do, because that is doing then you're manipulating the risk structure that's inherent in base rates in a way that takes away all the you're messing with the whole kind of model of the base rate paradigm. But just from my perspective, for the same reason that a deferred asset isn't single issue rate making, a major storm cost recovery tracker could be separately adjusted. I will say that I'll repeat all the same stuff I said. I won't actually repeat it to waste everybody's time, but all the things I said before about the Z factor still very much apply from our perspective, that we need to be really careful about deciding, well, when do we depart from that level of risk? Like how big should a storm be to decide that we're giving it this separate rate treatment? And especially with, the very concerning condition of our planet, that's probably sadly going to be a moving target moving forward. So it makes what might make sense now to define as an exogenous out of nowhere storm in 10, 15 years might not. That might just be a continuing kind of baseline cost of business. So I don't know. That was sort of an additional thought, but hopefully that makes sense.
It does. Mr. Horton, I see you want to add on.
Yeah, just and Attorney Wheel mentioned it. I think the key distinction is when we're talking about single issue rate making, we're by definition talking about base rates in amounts that have been set in base rates at a representative level. So there are storm costs in base rates for storms that are below the catastrophic storm cost threshold. So those are storms that are more run-of-the-mill, expected to happen on an annual basis, for which there's no separate treatment. Our storm costs that fall into that category have grown substantially since the time that we last set base rates. And I would say that it would be a single issue rate making argument if I were to come to PURA with my handout asking for the costs of that expense to be raised in base rates without taking a comprehensive look at all other costs that PURA is setting in base rates, which is entirely different and separate from the storm costs that we're talking about that exceed that threshold. Those storm costs have been by design determined to be not included in base rates at a representative level. They have been determined to be catastrophic in nature and in size, so they will be treated on a separate basis by PURA, reviewed for prudence and allowed for funding to occur. The mechanism to pay for those costs is not a base rate mechanism, but it's saying that you have a set established amount. For Eversource, it's approaching $1 billion. Not to say that PURA has reviewed for prudence all of those costs, but the price tag is significant, not to be dealt with in base rates as a normal ebb and flow item, but as a dollar that has been determined to be recoverable upon a finding that it has been prudently incurred by the utility. So that here now, once we've kind of cleared that bar, we're not talking about a single issue rate making for base rates, an element that was included in base rates at a representative level. Now we're just talking about what's the best way to have customers pay for that avoids rate whiplash in rising costs on customer bills and can mitigate the carrying charge impact, because PURA's practice for that $1 billion regulatory asset has been to allow for carrying charges to start to being reflected once the recovery begins. So by reducing the amount that is outstanding, by having a mechanism operate outside of base rates, can achieve both of those things by having more gradual rate changes over time for customers, lowering the overall balance ultimately that would need to be paid, which lowers the carrying charge impact on customers. It's like if you have a credit card bill that has a 0% APR for 12 months and you put costs on that credit card bill, you're not going to pay interest until the day one of after the 12-month expires. If you can pay down that balance prior to that first payment being due, you're just saving carrying costs. You're saving interest expense that will be incurred. Again, it's entirely separate and different from a base rate item in a single issue rate making that's a component of base rates cost of service.
Thank you. Appreciate that discussion on the single issue rate making question. I think we had a couple more regarding storm costs. Mr. White.
Thank you. Question for UI, and I know that we discussed this in a prior tech meeting, but I just want to be clear on this. With regard to the revised straw proposal, the guidance regarding 90-day submission of invoices, what is the maximum window of time that the company would need to gather storm cost documentation and submit for a prudency review?
I'm not sure that I could cite a specific number of days, but I think, consistent with what we've put in these written comments and consistent with what I've said in prior written comment, technical meetings in this proceeding, UI's vendors, like third-party businesses who provide support to us, typically do invoice the company with some urgency because they require the company to pay invoices for them to get paid. However, when UI receives mutual assistance from other utilities, their invoices may not be as timely as 90 days and have, in UI's experience, taken significantly longer than this 90-day threshold. And that's why our other jurisdictions who have storm cost mechanisms that involve more regular rate updates for storm costs, they include initial filings and then subsequent updates for the fact that invoices, just like I described, may come in over a period significantly longer than 90 days. I think in a past technical meeting in this proceeding, I talked about the experience of UI's affiliate, the Central Maine Power Company, who has a storm cost mechanism that allows for some level of storm cost to be reflected in their, it's called the annual compliance filing. It's tantamount to the RAM. It allows some amount of storm costs to be reflected in their annual compliance filing. They do have a relatively quick initial filing, but there is a built-in update approximately 6 months after the end of the year. And in extreme instances, there's been a subsequent true up in the subsequent year's filing for fact patterns, just like I've described here.
Thank you.
I mean, very similar from the Eversource perspective. We couldn't put a time frame on it for the reason Mr. Hurwitz said. Although I do, if the intent were to try to get on a more regular cadence of review, I would agree that you could certainly fashion a framework that allows for an initial filing to be made in some, period of time after the date of the storm, with updates for invoices that come in after, or for invoices that haven't been fully reviewed by the time you reach whatever that milestone is. We go through an extensive review process, and these invoices are fairly long and complex, where we go through and we recalculate all of the charges. We enter into, potentially, depending on the result of that review, back and forth with the vendor or the contractor to get better support or different support. So we don't see the value in racing to have something filed. However, we certainly see the value in having a more regular cadence of review so that we're not stacking up tens of thousands of invoices and, potentially hundreds of thousands of pages for review in a prudency review that takes place much less frequently. But we could never support a pure time bar that anything after some date, whatever that date is, would be automatically determined to be imprudent because we didn't meet an arbitrary time frame. That wouldn't be something that we would ever support.
Thank you. Anyone else?
Sure, Tom Wheel from OCC. I don't know whether 60 days or any particular day makes sense. I don't know anything about the billing, the invoicing requirements of the utilities, but I do just want to throw in a kind of plug for it, or at least throw in the thought that for those of us who are charged with reviewing the costs that are being sought to be recovered in a storm proceeding, it gets increasingly difficult to analyze older and older invoices for prudence, partially because of the reality that I think, if you ask someone a question about an invoice that's 7 years old, acknowledging that, like, if we're doing a 4-year review cycle and maybe even more frequent, that won't be an issue moving forward. But the reality that the older costs are, the harder it is to ultimately ask questions, institutional memories fade, evidence gets stale. So we do generally appreciate that's our understanding of the intent of the condition in the straw proposal, is to ensure that, that that the evidence is fresh enough to actually review when it's being reviewed. So again, not sure, we don't have thoughts on the particular kind of threshold, but we do kind of support the idea of, we don't want to see a future where in a storm cost, multiple multi-year rate plans later, a company can come back and say, hey, remember that storm review from 18 years ago? We found this invoice. Like that would not be acceptable to us.
Eversource could support an 18-year cutoff.
All right. I don't see anybody else. Thank you. Next question is for Eversource. Again, on storm costs on the immediate restoration of service. You can refer to Eversource comments on page 50. What is an appropriate time frame for incurring, not paying, but incurring storm costs? And do different, perhaps different activities have different timeframes?
Yeah, great question. So on this one, again, I think establishing a hard and fast rule, we wouldn't support, but certainly there is a point in time when we would expect to be challenged by having a storm cost that we're presenting as being incremental to a storm restoration event, but happened, pick a time frame after the restoration of service. So really the point that we're making is when we are in the middle of a storm restoration effort and our frontline men and women are out working in extreme conditions with the number one goal of safely restoring service as quickly as possible, there are times when we will make a temporary repair in order to get the lights on faster, knowing that we'll need to come back and make that temporary repair permanent. And so we do have situations and circumstances where we do that and know that we'll continue to incur an incremental expense after service has been fully restored. And so we don't agree that there should be a firm cutoff at the date of or the time of restoration, because there could be, but that any costs that come in after that point in time, just like the cost that's incurred during the restoration itself, we would still expect to have to demonstrate to PURA's satisfaction that those costs were incremental and related to the restoration itself. But we've seen some of that restoration work at times take weeks or sometimes even months or longer, because a lot of the time after that storm is completed, the temporary repair, it can be something that is prioritized within our normal, work week. And so there are competing circumstances that affect our workforce. And so it can take time for us to get back. A roundabout way of saying, again, I wouldn't support there being a firm cutoff, but certainly you reach a point in time where it strains credibility, and we understand that. But I think it should all just be subject to that same standard of us having to prove to your satisfaction that it was truly incremental and associated with the restoration event that we claim it did.
Thank you. When you use the words temporary and permanent, my head went to sort of bifurcating it as temporary being O&M and permanent being capital. Is it more complicated than that?
It is, yes, because we're not talking about for incremental storm costs. We're not talking about capital improvements that are made. And I don't have firsthand knowledge myself of what the type of an expense could be that's incurred during an event. But like I said, I know there are circumstances where we'll make it temporary, we'll string up a line in order to get it back up, but we'll need to go back and, put up a cross arm and make it more permanent in that regard, while still not rising to the level of a capital expenditure.
Okay.
For a span of wire or for a replacement of a pole, but just something that was done safely, but still temporarily, that needs to be revisited, but still as an expense in nature.
Thank you.
Sure.
UI?
Yeah, to continue emphasizing the point Mr. Horton was just making, and again, drawing from the experience of UI's affiliate, the Central Maine Power Company, there were two particular storms at the end of 2022 winter storms, Elliott and Diaz. One hit December 17th and the other hit December 23rd. And these were two, for CMP, very significant storms. And in that circumstance, CMP completed the restoration of power following the first storm, subject to check. I want to say it was Winter Storm Diaz, in something like 3 days, leaving a 2 to 3 day gap between when restoration from the first significant storm happened and when the second significant storm hit. But CMP continued incurring storm restoration expenses because CMP had prioritized getting the lights back on for its customers in that, critical, most cold time of the year, holiday season for most of CMP's customers. But it's not enough to just turn the lights back on. There may still be what CMP called trouble tickets. You might have a limb on line, you might have some peripheral damage to the system that wasn't enough to cause an outage. But in that case, CMP determined, and the commission ultimately agreed, that it was prudent for CMP to continue working to restore that type of damage, even though it was not causing an outage at that particular moment, because there was another very significant storm on the horizon that was known at that time. And had CMP not taken the steps to restore that damage, even though there might not have been a customer out because of that damage, it was about to get a whole lot worse because of the imminence of the second storm event. So I just say all this to add, that was an example of CMP or a utility in the Northeast prioritizing the continued storm work, even after that last customer was turned back on, because one, it was necessary to get the system back in good working order, and then two, it was necessary to make that next storm on the horizon much less bad than it otherwise would have been.
Thank you. I think we'll take a break in just a minute. I have one last question on storms, and then we can get to the break. And this relates, OCC, to written comments that you submitted regarding the every 2 years of looking at storms as a potential alternative to what's in the revised straw proposal, citing to that alleviating administrative burden in a rate case. And for OCC and for CIEC, who are engaged in the review of those materials. And I guess to maybe just look at it on the other side, one of the promises or potential promises of PBR is less frequent rate cases and easing administrative burden in that regard. And so does introducing a review within, like in the interim period between the years of a 4-year multi-year rate plan, does that negate in some regard the administrative burden, or is that something that does not concern you as parties that often participate in rate cases?
I was just making sure Attorney Goodman didn't want to go first. Tom Wheel from OCC again. I certainly understand the point that if what we're trying to do here is to sort of spread rate cases apart so that we can kind of get work done between rate cases, which is, I'll tell you, very difficult right now for us. I understand that. I will say, I mean, from our perspective, it just gets to be, there's only so much focus that can be offered, that can be provided in a 350-day period. And the more that gets kind of squeezed into a rate case review, the less scrutiny we can apply to all of it. So and storm cases, at least, the way that they are coming in now are huge. Like there's a massive amount of data to pour through. And from our perspective, kind of like adding that, for instance, if we had to do a storm case at the level of magnitude, for instance, that's currently happening for Eversource, if we had to incorporate that into UI's current pending rate case, I don't even know. I mean, we're already frankly struggling with doing both at the same time as it is, but devoting all the same resources to one single case would be really, really difficult for us. And I think one point that we were hoping to make in the straw proposal is that, despite the doom and gloom comments I made earlier, hopefully there aren't going to be catastrophic storms every single year into the future. So there could be circumstances where there is no need for a storm review in between rate cases. So that's why we suggested what made sense to us would be to sort of kind of like set the expectation that every 2 years there would be a space for storm cost review as sort of like a relief valve if it's necessary. And if it isn't necessary, we can just skip it, which would be great. But hopefully that makes sense. It's mostly about like the level of scrutiny that we can apply to the whole body of evidence in a particular case gets diluted the more evidence there is.
Thank you, Attorney Wheel. Attorney Goodman, do you want to add?
Yes, thank you. Generally, I would agree with the comments of Attorney Wheel with a couple additional notes. One, sorry. I think the idea of more regular periodic reviews of storm costs, or at least having the space to conduct more regular reviews makes sense to try to avoid a significant buildup. I think Mr. Horton earlier referred to Eversource's storm cost account currently being, did you say $1 billion or more? And if setting aside whatever the burden might be of lumping this review into the rate case, I think there's a strong interest in trying to avoid the buildup of an account like that has to be dealt with because there's a significant rate shock that comes along with that. So I think that just agree with Attorney Wheel. I think we wouldn't oppose to including it in the rate case. We think it should be part of that, but also providing that additional space outside of the rate case, whether it's every 2 years or I don't know what the appropriate cadence would be, but to try to make sure that there's visibility by the authority and all other parties as to what those balances are and whether they need to be dealt with in some way outside of the rate case.
All right, thank you very much.
And I know that was for the non-utilities, but if I could just add a couple of comments on that. I think agree with everything that's been said. Again, I think the important thing as it relates to these storm costs, in Eversource's case, the $1 billion, these are costs that are decidedly not part of base rates in a rate case. If the goal of any rate case is to set rates that reflect a representative level of the utilities cost of service in a rate year, these storm costs have been specifically and explicitly pulled out of that framework altogether. So the fact that historically the rate recovery has been established in a rate case doesn't mean that we're setting those costs again as a single issue, as a representative level going forward. The framework is that $1 billion will need to be reviewed and approved for recovery at some point by PURA. So if your choices are to try to cram it into a statutorily required 350-day review and then cram the rate change on top of what will amount to a rate increase, if a rate case is being conducted lawfully, certainly from my perspective, it will result in a rate increase. And if you look at the history, there's evidence to show. I looked at a database going back to 1977, showing the result of all rate cases that happened over that time throughout the United States. Greater than 92% of them resulted in a rate increase for customers, which is not surprising, given that costs for utilities rise just like any other business. And the fact that a rate case, when filed, is done because the revenues are insufficient to support the business. So if we're looking at a scenario where on the one hand, we have $1 billion that ultimately needs to be recovered, or some portion of that after the prudency review, and deciding whether or not we should look at that $1 billion of documentation in a statutorily required 350-day review window, where PURA has no choice but to issue a decision with that window under the law, and then have the rate change on top of every other cost that's changing. Or in the alternative, look at a scenario where we have that review happening more frequently in more manageable morsels and having the rate change for customers be more gradual over time. I would see, and having the carrying cost impact on customers be lower. I really don't see any viable argument to do the former. I see no reason why we should continue on this paradigm. It may have worked in the past where the storm cost balance was not $1 billion, not accruing at $200 million a year on average in the case of Eversource. That's a lot of money that we're talking about tacking onto customer bills. So I think it would be the wise thing for us to look at some other framework for a more regular review and for a more regular rate change as being in the best interest of customers, as well as ensuring that the rates reflect the costs over time, not trying to cram it into a rate case. I see no viable argument to do that whatsoever.
Thank you, Mr. Horton.
You're welcome.
Any last words on storm costs? Okay, then, excuse me, let's take a break now and return commissioners at 2:45, if that works for you. Okay, 2:45, we'll resume.
reconvene today's technical meeting and hand it back to Mr. Kramer.
Thank you, Commissioner Arconti. Thank you, Commissioner Karen. All right, so we're
Mr. Kramer?
making progress. Yes.
Sorry to interrupt. I did on our break, we discussed one other element of storm cost proposal that if it's okay to you, I thought would be worth mentioning. We did discuss
Please,
it
go
in our
ahead.
comments, but in our comments, touched upon it extensively, but within the straw proposal, as it relates to carrying charges on the storm funding balance, it seemed to contemplate an asymmetrical application where the utilities would be accruing and paying carrying charges at the weighted average cost of capital for receipts for the reserve funding and not doing the same treatment for the costs that have been incurred for the storm restoration expenses, which I don't need to get into it now unless there are questions or other thoughts on it, but it's in our view entirely arbitrary and not reflective of the real costs that have been incurred by the company. As I said, in our case, it's approaching $1 billion, far in excess of any amounts that have been recovered in rates, and it would be wholly inappropriate from a rate-making perspective or just a straight corporate finance or finance perspective, period, to contemplate accruing, carrying charges in only one side of the equation, taking into account only receipts and revenues, but not taking into account the actual costs that have been incurred. And so we strongly oppose any sort of framework like that.
Thank you. Would anyone like to comment on that point in particular? Okay. All right. Thank you, Mr. Horton. So we are making progress through our agenda a little bit ahead of schedule. We'll see if we can keep that pace. The next topic we're going to get to is to discuss the CT bar, the proposed capital funding mechanism. But before we do, I think, Mr. White, you had a question to take us back to one other topic for clarification.
Yes, so a question for Eversource. What would the company recommend for a materiality threshold for the Z factor?
For the Z factor, meaning the exogenous factor, not including storms, we had argued for 0.5% of distribution revenues, and we put in our comments examples from other jurisdictions that generally track with that threshold as being a level of materiality.
Thank you. Eversource, or sorry, UI.
Was the question just, do we have a specific proposal for a materiality threshold for the Z factor?
Yes.
I think in our most recent set of written comments, we proposed contemplating not a materiality threshold, but rather a materiality guideline for the reasons that I touched on earlier today.
Okay.
And I'd be happy to reiterate those if that would be helpful.
That's okay, right?
But if I'm not mistaken, that guideline was at what, 1%, right?
Correct.
Okay, thank you.
And a question for UI. What would the company recommend for a materiality threshold for storm costs?
I think that's a question that would be best visited in a rate case, balancing the factors that Eversource touched on earlier of making sure that you draw the line for where risk gets divvied up between the utility and its customers in a way that makes the most sense for everyone. But we think it would be inappropriate to make any determinations in that regard outside of a rate case for the reasons that I described earlier.
Thank you. Eversource?
I completely agree, and I think you really do need to look at the combination of the storms that fall below that threshold, because again, if a rate case is being conducted in the way that it's supposed to, any amount below whatever that threshold is that's set, PURA should be endeavoring to set a representative level of those storms in base rates. Otherwise, it's creating an artificial framework where costs are just being left off the table. So I think it is really important and necessary to view that threshold in the context of a rate case. And I think it would depend on each utility's experience and the level of costs, both that occurred in the test year or potentially in a representative level if the test year was too high or too low. I don't think it's appropriate to set it at a fixed percentage of revenues without understanding what's the impact of setting the threshold too high or too low below that. For Eversource, the 1% of total distribution revenues would be around $15 to $16 million, which is a very large event, which would mean that you'd have a number of also very large events that you'd be having to incorporate into base rates. That's where we got as our outlines in our comments, that if you set the level that high, you might be thinking, well, that's good for customers because then that means that fewer storms would qualify, which they would, except that customers would then end up having to pay annually whatever that representative level of storm costs is, even if we didn't incur it. And we showed just over the last 4 years, there's broad variability in the actual storms that meet that threshold, so that customers would end up significantly overpaying or underpaying depending on the randomness of the year. So we think for that reason, it's really appropriate and important to look at that threshold in the context of a rate case and the customer impact of setting it too high or too low. But at least if you set it too low, then you're building in less into base rates and ensuring then that customers would only ever be paying for the amount that's ultimately deemed prudent. So I think you have to just balance all those competing interests, and the right place to do that is in a rate case.
Thank you.
Just one quick follow-up that only occurred to me now, but just to state it explicitly, it doesn't seem to me there's any logical reason you could not have different thresholds for non-storm Z-factor costs and storm-related Z-factor costs. I understand obviously the intuitive appeal of making those two things the same, but I think we've talked about and heard that the considerations in setting those two numbers are not exactly the same. So it seems theoretically conceivable to me that you could have different thresholds for both.
Hi, Tom Wheel from OCC. Again, I agree with that. I think the difference in my mind between the two is that the Z factor is supposed to be for events that are unforeseeable altogether, the kinds of costs that like no one could expect the company would have to incur, whereas storms are a foreseeable. I mean, we all know the company will have to incur a storm restoration cost. It's just a question of how much is appropriate to set in base rates versus a level above base rates. So in my mind, I agree with both companies. Actually, I think that, like I said before, I think first, it makes sense to me when you're in a rate case to set a level of base rate storm cost recovery that presumably is going to change over time as the climate changes. And then the degree to which a catastrophic storm is materially above that would depend basically on how much we think the company will have to incur, as a baseline level, which is different than the Z factor where there's nothing at all, presumably in base rates to account for the cost.
Thank you. Anyone else? Moving on to the CT bar. Question for Eversource in relation to OCC's written comments, pages 13 to 16, as well as the comments earlier during this meeting. Does Eversource believe that the CT bar can be configured in such a way to alleviate OCC's concerns regarding the risk of double counting with the ARM, the TFP output, or a potential discrete cost tracker?
Yes, and I did ask Mr. John Callan to sit up here with me. He's much more knowledgeable about the mechanics of the CT bar and the K bar in Massachusetts. But on this one, I think I can field. I would say the answer is yes, although I completely understand the sentiment that Attorney Wheel mentioned. As it relates to the K bar in Massachusetts and our understanding of the CT bar here in Connecticut, at least if you're comparing the revenue support provided by the CT bar as compared to the revenue support provided by base rates working in tandem with the I-X, those two things are actually very easy to ensure you're not double counting, because the first step in the calculus is to take the cast-off rates, which includes both capital and expense-related components, and adjust them by the formula I-X. And so the first step, and then determining the amount of revenues that are provided for by the CT bar or the K bar. Well, let me take a step back. You would do that step on its own to determine how much revenue support is being provided by base rates as adjusted by the I-X. And then separately, you'd calculate how much revenue support is provided for under the K bar or the CT bar, how much revenue support is indicated as required, I should say. And then you would deduct from that amount the capital support provided via the operation of base rates times the I minus X. So said differently, if you said you had $100 revenue requirement as your base rates, and that's comprised of, let's just say, $40 of capital-related costs and $60 of O&M. The first step after a rate case would be to take that $100 and apply the I minus X formula to it. So that's going to adjust both the $40 for capital and the $60 for expense. And let's say after that calculus, you end up with math that says you've got $45 now of capital support in base rates. So 40 as adjusted by the I minus X gives us $45 of capital-related support. Then separately, you calculate the revenue requirement for the CT bar. And let's say that that says that you should have an incremental $10 to support the CT bar investments. Rather than recovering the $10, you would deduct the $5 increment that is, produced by base rates times the I minus X. Somehow, Mr. White, it seemed like you were tracking me on that one, so kudos to you. But I think the point is that you deduct the amount of the capital support from base rates as a necessary operation of the formula so that you're not getting both, revenue support for the CT bar and the operation of the I minus X. As it relates to any capital that's flowing through a capital cost recovery mechanism, perhaps outside of either base rates or this CT bar, you just simply wouldn't include it in the calculation at all. So it would be up to the utility to demonstrate again to Pura's satisfaction that we're not double counting, we're not including that capital additions either in the CT bar or in base rates, but it's operating completely outside and separate. And we would have to ensure that we've done that to Pura's satisfaction before getting any revenue support for that.
Thank you. Any other comments from anybody? Okay.
Well, I guess maybe a natural follow-up then, Attorney Wheel. Does the discussion that Mr. Horton just provided on the way in which those mechanisms can be established as mutually exclusive, does that assuage those concerns that OCC raised in written comments? Are there others to still unpack here? I'd like to understand that better.
I think I understand in theory. I honestly don't really get how, I'll back up a little. If I minus X is supposed to adjust, I'll back up even further. The point of the revenue cap formula is to basically take as we talked about before, I think several times in this room, is to sort of take the company's revenue requirement and more or less keep it static. Like if you imagine that the amount of money that it takes to run the company all in is basically going to be the same from year to year. Well, it isn't, because you need to account for inflation and potentially the productivity of the industry. So that's my understanding of what the I minus X does. So with respect to plant, what that does is take, plant is kind of, I think of it as it's like a cycle, right? Like it's what you're paying for in plant isn't actually just the depreciable life of one asset, but like when that asset expires, you'd have the same revenue that was paying for that now dead asset to pay for the new asset, and it's sort of like constantly rolling over, right? So if you're adjusting rate base, and specifically plant by the revenue necessary to support plant by I minus X, what you're doing theoretically is just taking that same, what you should be doing is taking that same level of revenue support and keeping it constant. So providing enough revenue to just support the level of plant that's in the system now, nothing incremental. So I don't really get why you're making the adjustment Mr. Horton just talked about, where if you're taking incremental plant, if you're adding enough revenue to support plant that's in addition to what's already accounted for in rate base, why you'd be subtracting the amount that, it seems to me that would provide less revenue than necessary to take care of the plant that isn't incremental. So I don't really, that's where I get kind of lost in the sauce here on the CT bar. But I'll also say, like, our concerns generally weren't so much that a model like this can't work. It was more that specifically, as I think Mr. Horton was talking about earlier, the interplay between the IDSP and the K-bar, CT bar is really important. Like we're just reluctant to say, sure, we totally agree with this model of the CT bar, because we still don't really know what the CT bar looks like. Like what exactly how are we determining the revenue requirement for the CT bar is still a mystery to us.
Okay, fair enough. Thank you. I think we've got plenty more questions along the CT bar to dig into, so let's keep going.
So, Laura, if you could put up this spreadsheet. So we're gonna look at Eversource's model. It should be UPA, the response to interrogatory UPA 76, attachment 1. And I'm hoping people will be able to see this. If not, if you have computers, you can follow along. The tab name steps 1 through 5. I think that's the name of it. Yeah, okay.
And Ms. Lupley, I'm sorry, could you do one more click in on the Zoom? I didn't bring my glasses. Thank you.
So question for Eversource, can the company explain where it calculated the historical planned versus unplanned capital additions as described in steps 1 and 4?
I can start and then Mr. Callen will clean up my mess. But I think what we pointed this out in our comments, which is that the distinction in the straw proposal around, capital that would qualify for the CT bar treatment and that which wouldn't was unclear to us to what Pura was trying to get at. So I think what we've tried to model here is if you imagine that the IDSP sets a projected level of spending that is agreed to by Pura, and then that informs the CT bar revenue support. We didn't then model in variability. What we were trying to hone in on was to show that even a perfect utility operating with perfect information and with revenues that perfectly match its expenses and storms, which is significant, those are unrealistic assumptions. But we were trying to show Pura that even if you had a perfect utility operating with the benefit of hindsight, and ensuring that the revenues that are produced by the I-X formula perfectly match expenses in every single way, O&M expenses in every respect. This is a framework that's not designed to provide that utility with an opportunity to earn the level of net income that's required for it to attract the capital that it needs to pay for the infrastructure costs that are reflected in that IDSP. So not even taking into account if there are differences for actual investments as compared to what was planned at the time the IDSP was set. We're essentially saying that if everything happens exactly as we could have forecast on paper, still is designed to be producing revenues that don't provide that required return that Pura itself would have said is necessary to attract capital to the state of Connecticut.
Yeah, that's perfect. Do you have the, not right now, right here, but do you have the unplanned numbers? I mean, my understanding based on when I read through various documentation here at Pura about your submissions, I recall seeing planned and unplanned. So those are numbers that you have. Is that fair to say? Like a 5-year history, like an average of the past 5 years of unplanned capital additions?
Are you talking about like emergent capital, like for emergent conditions? I think it's a definitional issue.
Okay, yeah, it might be, but I think that sounds like it would be what I'm looking for. Stuff that was unexpected, but you ended up having to do it. It was not in the IDSP, but ultimately you had to do it just to maintain reliable, resilient system, something along those lines.
I have to admit, I don't know what Pura is thinking. I'm not as close on the IDSP docket. So in my mind, the simple my simple understanding of what would go into that IDSP would be, and maybe this is clarifying, it would be things that are planned based on what we project for customer growth or adoption of electric vehicles or what have you, that all that goes into our system plan over the 5-year period. But we would also have, and usually this is informed by historical actuals, but we would have a bogey, a level of unplanned work that just always comes up, customer-driven work or emerging conditions that emerge on the system that have to be addressed. The IDSP, and this gets back to our earlier point, the IDSP, if it is to inform the CT bar and to result in a framework that works cohesively and gives enough revenue so that the utility can do all the things it needs to, it's going to have to take into account all those things. Just like I was saying about, the customer discussion we were having earlier. Well, we don't get to control customers that, require us to make capital expenditures to serve them. We don't know when that's going to happen. We can try to come up with a bogey. We have rough estimates based on historical experience of what's going to happen, but to project with accuracy a customer interconnection 3 or 4 years from now, or know what that's going to cost and when it's going to come online, we can't do that. So having the CT bar set based on a level of capital that's in the IDSP, I think our initial understanding of this updated framework is that the IDSP capital would be inclusive of everything, both planned and unplanned work. And then that would factor into the CT bar calculus. It would have to, or else we're leaving a big piece off the table. And so when we modeled this out here again, we were essentially saying that this is inclusive of all capital that we would spend, whether it's for targeted specific projects that we're intending to undertake on our own, or for things that are driven by emergent conditions, or for customer requests or regulatory requirements. All those things impact the capital that we have to attract to serve our customers, and then would need to be reflected in this rate-making framework in some way or another.
Okay, yeah, I think so. Based on what you're saying, I'm thinking that the unplanned would be the customer issues, emergent issues, in how I was thinking about the unplanned capital.
And those are significant. Those are hundreds of millions of dollars a year. It's a large portion of our capital work is driven by those requirements. And so, again, we're here just saying if the IDSP is inclusive of all capital, forces, requirements, or whatever, even with that, and if the IDSP is designed to inform the CT bar and it's working as we think it would, again, the idea was to show that because of how it has been designed in the revised straw proposal, although significantly, improved from where we started in December of 2023, with the straw proposal at that time, it's still leaving off the table large capital that would make it impossible for a utility to be able to accept, the requirements of PBR and to actually take this leap of faith and move forward. It's just, we know it won't work because it will be designed on its face to not produce enough revenues so that the dollars in can support the services going out, especially if we're talking about PBR, where the idea is to have the utility performing better in new and different ways. This is all based on information that we have today, based on the IDSP. It's based on what we know today, which doesn't contemplate doing different things that, PURA would ask us to in that PBR REO2 framework with new metrics and new areas of focus.
Mr. Horton, I'm just to make sure I understand what is represented in the model then. Is it the case that what we termed as unplanned or emergent or customer driven is included, or that was excluded from the number that's included here?
They would be included,
Okay.
representative level of unplanned, but to the extent that actual unplanned emergent work exists, it wouldn't be captured by this model, neither the revenues nor the investment. So for
Sorry
example,
to interject just for a moment. So the bogey, to use the term Mr. Horton used, is, sorry about that, is included in here.
Yeah.
But your point is that the actual emergent costs are not known yet, so those can't be included, obviously.
Right. So if for example, there was 200 million of emergent work somehow and customer-driven work somehow accounted for in the IDSP, and the actual value is 203, that $3 million difference isn't captured here. So the revenues aren't capturing the impact of that 3 million, but neither is the investment. So what would actually happen is ROEs would probably be lower because the investment would happen and the revenues would happen later. So that dynamic's not captured in here.
Okay. And if I'm just going to use the term for simplification, the bogey, if that assumption about the unplanned work is included, but if I recall, it wasn't specifically identified as such. Is that the case, that amount, let's say it's 200 million, like you said, but that 200 million is not like separately identified from the total basis that's included in this calculation? Is that accurate?
I'm not sure I understand the question. You mean if the IDSP doesn't adequately define what is like a bogey for unplanned? Is that what?
I'll come back to that. I want to reformulate my question a little bit more because I'm having a hard time
Well,
reading the screen, but
I know it is tough, but I'm able to zoom in here. If you look at, like, if you go to the right, don't go down. If you just go to the right, it's on line 14. See how it says actual plant additions exactly equal IDSP plant additions? So what we're saying is whatever the category, here we're saying that the IDSP sets a level of projected plant additions for all capital requirements that are put upon Eversource. So we set a level, and it's if you scroll back to the left, you can see the additions now. So in 2030, it looks like it's 506 million. What we're saying is that within this modeling exercise, nice and neat on a piece of paper and in a great Excel spreadsheet, not taking into account any real world impacts that happen every day, we're just modeling out what would happen if we had perfect information. And when we set that IDSP, we walked away and we could spend exactly that, not a penny more, not a penny less. That would include emergent conditions, customer connections, planned reliability investments, resiliency investments, plus everything else that's encompassed in that IDSP. We're trying to model out on that line. So there's no differential more or less than, what we actually spend in the system in any given year.
thank you. And maybe this is a better way to ask my question is, if I'm looking at line 14, in 2022, is the bogey included in the 478?
Right, that would be
Okay.
all capital additions.
All right, but we don't know just based on this, but we could. The 478 doesn't identify the specific number of the bogey.
I'm so stuck. I shouldn't have used that word.
It's helpful, but
Why?
I have to
But
say it
What's the
5,000
point? I mean, this is trying to say we have to spend capital, and if you look at our capital plan, there are a number of drivers. There's customer, there's regulatory, there's emergent conditions. When a car strikes a pole, like, we have an idea based on history, but we don't know and can't plan for it. But yet we have to go and repair that pole. So there's a cost of every single one of those things, regardless of the driver. Whether we plan for it or not, a prudent utility is going to be spending dollars in certain categories. So I'm sorry, but I would love to understand, why does it matter so much? Here, we're just saying purely on the financial side of the house, when you set up a framework that takes into account all capital resources that the utility has to attract to serve its customers in the state of Connecticut, the framework has to, in my mind, accommodate it regardless of whether it was planned or unplanned, emergent or not, whatever. The capital has to be spent to get that pole back up and running. And so whether we plan for it or not, we didn't think it was an important distinction, because we were just trying to hone in on, based on the mechanics of the CT bar outlined in the straw proposal, how would it work just if we had perfect information, which we don't. We know we're going to be off.
Yeah, I appreciate that. I think part of the questions that we have today related to the Excel workbook is to make sure that we're understanding how the companies have interpreted the steps included in the revised straw proposal. So it's a bit pedantic, but helps us understand what assumptions or how it was translated into an Excel format. So I think that you've answered my question about the unplanned work being included, for example, in line 14 in 2022 in the 478. And yeah, so I think that answers my question in a specific way. So I'll give it back to Mr. White.
Could I just add one point?
Please. And it's Mr. Callan, right?
Sorry, yes.
Thank
Yep,
you.
Jonathan Callan. We're assuming that, like, line 24, the values that are in the IDSP include some values for what we're saying, the bogey. The emergent work, the customer-driven work, we're assuming it's not a more defined set of capital, like only for substations, only for capacity. You know, we're saying it's all capital that's not otherwise attributable to some other mechanism like, you know, grid mod or AMI or whatever.
Great, thank you. That's helpful. Please.
It's a comment slash, if I could ask a clarification from Mr. Horton or both companies. Perhaps it's just a semantic or because of what the focus of the current discussion is, what I'm hearing is about everything being additive. You know, there's the capital budgets reflected in the capital plan. There's emergent work, which I understand is always going to come up, as you said. You can never forecast with perfect precision what the needs will be. But just in the way that it's been discussed, it sounds like everything is additive. What I'm not hearing is the concept of the utilities should be working within their capital budgets and working to whatever the budget for the year or years are. So as some of that emergent work comes up, I'd assume that the company is, instead of thinking of it as always an additive to the budget, that you're looking at what other projects can be delayed or deferred or potentially even canceled, maybe not canceled, but push off some of that other spending in order to stay within a capital budget. So if staff would indulge me, if I could ask the company to kind of explain how you see that management within a budget as fitting in with the discussion that we were just having about a base rate revenue requirement impact for a capital budget plus a CT bar and these other things, which again, shouldn't just be additive to each other.
I completely agree. That's such a good point. And I think, our position has been, I hope, consistent from the beginning that when we get to the end of this PBR framework, we need to be looking at all three of these tracks as one. You've got the IDSP, you've got the metrics and REO2, and then you have the rate-making framework here in REO1. In my mind, the way they should link up is IDSP says, here's all the things that we consider when planning for our system, the forces upon us that require us to plan or unplanned, emergent conditions that we have to deal with. That would be dealt with in that framework. And at the end of the day, you'd end up with a framework that says, we agree, or whatever form that takes, that we agree with the utilities planning standard. And here's the investments, or at least the investment philosophy for the infrastructure that's going to be needed over a period of time. Similarly, in REO2, where Pure is looking at metrics, there we're presumably going to be held to account for new and different performance incentive mechanisms or scorecards or reporting metrics. That is, the idea of the whole thing is to make sure that we're able to serve our customers in new and different ways. And then here we're talking about how are we going to ensure that we have the revenues to support each of those things. Dollars in equals services out. So it makes no sense to have an REO3 framework that says, yes, we agree with how you plan for emergent conditions or plan for resiliency or reliability. An REO2 framework that says we're going to penalize you or incentivize you for doing certain things or doing things differently, but then not have an REO1 framework that says we're going to provide the level of revenue so that you can do either of those things. They need to go together. And I think that at the end of the day, it should be designed in a way that does exactly what you're saying, is that we should be incentivized to being the stewards of the system and those ultimately responsible for the investment decisions, have the incentive structure ensuring that we're able to execute as best we can on all three of those fronts, and to do so with the least amount of money possible, so that ultimately we're able to achieve the benefits of PBR and to keep rates low. And we did have comments as well on the design of the CT bar, where I can understand the reason for putting it into this REO1 framework. There's the asymmetrical reconciliation if actual additions are lower than the amount that was determined in the IDSP. But I think, Attorney Goodman, to your point, that actually takes away any incentive for us to try to achieve the objectives of REO2 or REO3 in the lowest possible way possible by having an asymmetrical downside-only reconciliation. I can understand the customer protection that we're trying to achieve by having that, but what you're actually doing is creating a paradigm where it's only a lose situation for customers or the utility. If we could install make an improvement for less than we thought at the point the IDSP was set, if you have only a downside adjustment, the utility would be financially motivated at least to fill in whatever gap that is, so that we're not penalized after the fact and try to get to spending what we thought we would, as opposed to being incentivized to spend less. Long way of saying, I think that ultimately the objective here ought to be that you've got the right incentives in place, that we're spending our dollars wisely and spending as few dollars as we possibly can. And that's why it's important to have a properly designed set of guardrails, which we haven't spent a lot of time talking about, but the earning sharing mechanism as being one in particular, that if you're incentivized to, install, if you don't have that downward only adjustment on the CT bar, customers are still assured to have protection, that efficiency that we're getting by not spending all that we thought we would at the time the IDSP is set, customers are still protected by having that broad-based ESM apply to the whole system or to the system as a whole, as opposed to looking at each individual component and trying to assess whether or not there's a winner or the customers lose. It's looking at the whole system collectively and saying, is this providing enough revenues? Because at the end of the day, that's how a company is run. It's looking at all revenues, all the forces that affect where we have to spend dollars, whether it's expense or capital, and saying, do we have enough dollars to provide the services that are needed? And keeping in mind that dollars in equals services out. If we don't, we can't pursue an improvement, in a certain area, and we couldn't pursue the investments in the IDSP. We should have that incentive framework in mind.
I don't disagree with anything that Mr. Horton just said, and maybe to say it in my own words, as I think of it, PBR, I think of it kind of in two parts. Part one is how do we set the rates in the first instance? And then part two, how do we make sure that customers are getting their money's worth for the rates that we set? And for setting rates in the first instance, I think that requires at first a realistic assessment of what you're asking the utilities to do. And I think in IDSP, like Mr. Horton, I have not been personally as involved in that, but I understand it contemplates a significant portion of the company's types of capital expenditures, but it doesn't contemplate all of them. I understand there was the discussion of emergent work earlier. My understanding is it also doesn't contemplate certain types of investments like IT or fleet. And so I think I was getting a little lost in the planned versus unplanned for those reasons. But broadly, we set rates, going in rates for rate year one based on our expectation of the utilities cost of service in rate year one. And then as Attorney Wheel described earlier, rate years 2, 3, and 4 require everyone to take the leap that we're going to set rates in those years, not based on a line by line revenue requirement like we have in years past, but rather a percentage escalation based on the revenue requirement in rate year one. And I hear your question and Attorney Wheel's comments earlier that, man, there's all these different types of capital. How can it be incremental if you have a base that already has everything? And I think, as I think of it, the CT bar mechanism, just like the K bar mechanism for other utilities operating in PBR in other jurisdictions, we say, yes, we're going to escalate the revenue requirement in rate year one using the certain percentage, but we know more about the utilities capital needs going forward. Maybe that knowledge comes from the utilities history, maybe it comes from their capital planning process, maybe it comes from integrated distribution system planning, wherever it comes from. We have this extra level of insight into the company's capital spending needs going forward. And as a result of that insight, we know that if we were to not provide any incremental capital funding mechanism, the utility is not going to have a reasonable chance to deliver the service we expect based on the rates that we're providing them. As Mr. Horton said, dollars in, service out. If the dollars don't go in, we can't provide the service coming out. So I think the word increment for me comes into play to, Attorney Wheel, your comment from earlier is, and I think Eversource's UPA 54, and I think this UPA 76 is a version of UPA 54, shows exactly how that works. The mechanism, as we at UI understand it, calculates the overall level of revenue support produced by the I minus X minus S formula, and then shows, well, when we layer in the specific knowledge that we have of capital, this is what the total revenue requirement is. And that total revenue requirement is more than just that results from the I minus X percentage escalation. And so even though this CT bar mechanism is broadly encompassing, the increment shows up when you compare it to that baseline that results from the I minus X escalation. I forget which of the steps it is, but I think this step 1 through 5 layout here in UPA 76 is a relatively clear illustration of that. And we submitted a similar attachment in our response to this question. To your point, where does the incentive for the utility to save come in? I think that comes once you've set the rate. You have to first set the rate that provides the utility with a reasonable opportunity, but not a guarantee to earn its authorized rate of return, and then ensure that there are incentives for the utility to operate efficiently. And like Eversource, we've indicated that it's important in our view for a well-designed capital funding mechanism to provide the utility an incentive to spend less, not more. And we think the downward-only nature of this reconciling mechanism to some extent, not to some extent, does remove that incentive. But there are other guardrails in this PBR plan as well that allow customer protections if we do spend less. For example, Mr. Horton touched on ESM. So I think I don't in any way mean to discount the importance of your question, because I think it's a very important one, but I think it's just the second step, if that makes sense. We have to first determine what is the level of revenue that is likely to provide the utility a reasonable opportunity, but not a guarantee to recover its costs and earn a fair rate of return. And then make sure the incentives are aligned so that the utility is going to deliver the level of performance that customers expect, have an incentive to spend less and not more, and all of that OCC, PURA, everyone has an opportunity to review the prudence of the utility's actions and all of those good things.
Very, very quickly, I appreciate both responses, and, the question really is, and CIC does not oppose the CT bar. The point is just that once between the I-X revenue cap formula, plus the CT bar, once rates are set to reflect a certain amount of capital investment, that should set a budget that the utilities work within, which means that at some point, there's going to have to be potentially difficult decisions made to delay or defer, or potentially even cancel projects to stay within the budget until you get to some future period, as opposed to there being some additional mechanism or opportunity to just further increase or defer those additional investments. We just want to make sure it was clear that the former would be part of the company's process, which I believe I hear would be. Thank you.
All right. I think we'll move on to a few more questions to dig further into the CT bar. So Mr. White, if you could.
Thank you. And first comment, just wondering about the models that were built, specifically thinking about the planned versus unplanned. And you had mentioned that you do have numbers, and it sounds like you have numbers in mind in regard to unplanned. We were talking about emergent issues, customer issues. Would it be possible to provide a supplemental filing that could break those two numbers out?
I guess it would depend on how we're defining unplanned. Unplanned as of right now, or unplanned like beyond that bogey. And I guess so to Doug's point earlier, I think the definition is critical.
So rather than getting into a big discussion about that, because I completely understand and appreciate what you're saying, you come up with a definition, maybe even touch base with UI based on the discussion today, and try to figure something out there to update a model.
And would it just be a matter of asking us to break out the categories behind line 14 and actual plant additions? Or is there some other, like our unplanned the unplanned categories, however we define it, not included in the IDSP? Perhaps that was a distinction I just didn't understand as we were developing this. Like, is there some impact on the result of this? Or is it just a matter of understanding better clarity of like, what are the components that go into the number on line 14?
I think likely breaking it out gives a better sense of what is behind it. And in calculating the CT bar as contemplated in the revised straw proposal, I think that the distinction between planned and unplanned does factor in.
So we'll go back and look. It sounds like what you're saying is a distinction that, again, I missed, which is that the unplanned investments wouldn't be in here, which would make, if that's true, our assessment of the CT bar, or is that not true?
I think unplanned would be in step 4.
They would be in step 4. Okay, so they would show up in a different part of the calculations. Okay, I guess I was just putting a pin in it that if they were to somehow come out, the revenue support provided by CT bar, which we haven't talked about, one of the major laws that we see still, but it would be that much less, which would make it that much less workable from our perspective. But if it comes in a different step, then we can.
Yeah, it would just come in a different step, and it's Yeah, I'm wondering about the flexibility you require in terms of unplanned versus planned. Planned, you have a really good idea. The unplanned, you don't. Thank you.
So is it just the concept you're after? So for example, if we built into this model, the ability to handle unplanned investments, are you just looking to see how it flows through mechanically? So for example, it's not necessarily that you care what is the number, if it's 200 million or 50 million or 10, whatever. Do you just want to see essentially that concept play out?
I'd like to see a number that you feel comfortable with. And when I say that, in my mind, and you can define it how you want.
Yep.
But in my mind, a 5-year average of what those unplanned, whatever those categories that you feel go into unplanned, what's a 5-year, a 10-year average, a 3-year?
Okay. Okay. Yep.
Flexible on from your part, as long as it's explained to us what's going into that.
Sure.
And Mr. White, at the risk of
Oh, yeah, I'm sorry. I wanted to defer to you too. I apologize.
at the risk of saying something inappropriate, would this be the sort of thing that could be synchronized somehow with REO3? Because I know one thing we were thinking about as we developed our financial analysis and, we contemplated the difference between emergent and non-emergent work. But my understanding is there are types of investment that could be called planned that are outside the scope of the IDSP. And so we took I'll borrow the dirty word, bogey approach too, recognizing that at the time we were developing the analysis, it wasn't clear to us how the categories were going to be split. And so that was really one of the factors that caused us to go that bogey route, was not yet having that clarity on the IDSP. And I'm just wondering, to get the types of insight that you're seeking, maybe there's a way to synchronize this request with the straw proposal. And I think we've got some written comments due in response to the straw proposal in REO3. I don't have those dates that close to my fingertips, but just to put that energy into the room.
Yeah, I think the planned and unplanned is a distinction that the revised straw proposal contemplates as material to how it's calculated. So to Mr. White's point, if the companies can file a supplement to their UPA, I think it is 76 responses that makes that distinction between planned and unplanned. Again, as the companies define it, that would be helpful. And with regard to how that factors into the IDSP, you're exactly right. There's a straw proposal that's tentatively scheduled for release on this Friday, April 4th. Okay. Thank you for
my apology.
Yeah, please.
Just to make sure we don't not do something you're asking us to do. Are you asking that we supplement our response to UPA 76 with this information?
Yes, please.
I understand.
Thank you. All right.
Another question for Eversource. Laura, if you could switch over to the tab PBR step 6, I think is the name. Okay. It appears that Eversource's your Excel spreadsheet is incorporating the CT bar revenue as of rate year 2, 2027, as opposed to rate year 1, 2026. Am I interpreting this correctly?
Yes. We assume that CT bar, the revenues related to it, would take effect with the first PBR term, so 1 year after going in rates.
So I'm just curious, why were you interpreting it to start in rate year 2 instead of in rate year 1? Any specific wording there?
Because going in revenue requirements presumably would capture the similar revenues, I guess? Because there's nothing that would have already been escalated at that point.
Okay, so I've just got like sort of bigger numbers in my head. Maybe I'm hearing you talk about like the I factor on top of a number from rate year 1 to rate year 2, but I'm talking about the 500 million that you have listed up there annually. It looks like it's starting in rate year 2 instead of in rate year 1.
So the first step of it is, or I'm sorry, it's the third step. The third step takes your depreciation and escalates it. So it escalates it, and then against that, you're gonna compare it to the IDSP. Whatever the difference is presumably the incremental capital. There's nothing to escalate. Depreciation would be the going in revenue requirement that we would have just established. So we did not interpret anywhere in here, I didn't interpret anywhere in here the concept of another rate taking effect at the same time as going in revenue requirements for base distribution capital.
Okay.
Am I saying that right?
Mr. White, if I could, I think, so that's that we've had this discussion actively in our pending PSNH rate case now, and I'm just to try to clarify, because it seems like from your question, but I'm trying to ask this of you as a question, was it the intent of the straw proposal to have the CT bar first rate adjustment go into effect on the same day that year one rates go into effect from a rate case?
That's how I was thinking you would respond, yeah, starting in on day one, rate year one.
So I think that has quite a lot of merit. We've talked about this in New Hampshire, and the reason it comes into play is that, so and I think we, both utilities, had a lot of consternation with the fact that we're establishing new deadlines and cutoffs for rate year one to set the going in rates. And we've talked a lot about our concerns, which is that any rate making paradigm has to have revenues that reflect the expenses to be incurred in the rate that those revenues are collected. And so by having cutoffs at the end of the evidentiary record or for adjustments up to the beginning of the rate year, all we know is that it's not going to reflect by its design the rate year one costs. So then in New Hampshire and in Massachusetts, Eversource, we operate in those three states. Each state relies upon a historical test year. So each state has historically only ever allowed actual plant additions to find their way into rates. And what we have now, not to get onto a whole soapbox as I tend to about like rate making and how the historical meets the present day, there is a disconnect because when we have revenue decoupling and we're setting a revenue target and we're focusing on just the capital additions portion of our revenue requirement, we're automatically creating a disconnect between what we expect the cost of service to be in rate year one as compared to what it was in the test year or when you're setting that chalk line. You're automatically disconnected unless your rate year capital additions match exactly with the level of depreciation expense that's set into going in rates. So you're automatically out of alignment, meaning whatever the rate that's going to be set for rate year one isn't going to reflect your cost of service for capital additions unless if you're relying on historical additions, unless your future level of expenditures matches exactly with the level of depreciation expense. You're automatically having a disconnect. And so the way to solve for that is to do what you're asking, which is to say that on the same time that you would have cast-off rates go into effect, you also would have a CT bar adjustment go into effect at the same time. And we saw that in Massachusetts the first time this paradigm was implemented, where you had base rates be set, again, using a historical known and measurable standard for plant additions. So there was a firm cutoff for plant additions that established cast-off rates for rate year one. Then the K-bar didn't go into effect until the start of rate year two. And it had a larger outsized impact than every year thereafter because you were basically catching up for the difference between investments from when the cutoff happened in the rate case and when that rate year two capital went into service. So you had a large increase for the first K-bar and then smaller adjustments each year thereafter. So in New Hampshire, we were asked the same question, which was, why is this first K-bar so big? And the reason is solved by what you're asking. You have just through natural operation of the CT bar or the K-bar, as we've modeled it here, you have a longer period of time that you're catching up for that capital differential because you are spending more than depreciation expense on capital. So you have a bigger catch-up period in that first CT bar. And one way to solve for it would be to have the first CT bar adjustment go into rates at the same time as the cast-off rates. So you could then pick almost whatever cutoff PURA was comfortable with. You could set the cutoff for plant additions be at the historical level at the end of the test year, as long as you're having the CT bar go into effect as of rate year one with all of the controls around it, you would still be setting a level of capital that reflects the expected capital costs to be incurred in the rate year. But as we've modeled it now, we're not doing that. We're basically, we have a gap between what's going into that rate year one or cast off rates or going in rates and when the first CT bar goes into effect at the start of rate year two. But we haven't modeled it to try to have them go into effect at the same time.
So, thank you for that. And I guess just to say it back and also to see if UI has a different perspective or if the OCC does, if the CT bar were to start in rate year one, would that mitigate the concern that was voiced earlier about the cutoff date for the evidentiary record in the rate case?
I mean, putting aside the other substantive concerns we have with the design of the CT bar, which I know that we'll get to, my answer would be yes, it would resolve those concerns because we would be getting to a place where at least conceptually by design, you have base rates, which would be set to reflect your capital costs, say through the end of the test year, right? So that the rate year is going to be 2 years after the end of the test year by the time you file and then have a year to litigate it. So going in rates, if you set it at the end of the test year for capital, would only capture capital spent through the end of the test year. And if you had the CT bar designed in a way, putting aside the other deficiencies that we do have serious concerns with, designed in a way that it was reflecting the rate year level of capital, not reflected for in those going in rates, then yes, you've solved the problem. Then you don't need to worry about whether it's the close of the evidentiary record or 6 days before or after, or whatever the cutoff is that you want to set. The design of the two mechanisms working together would get you to that opportunity if it's designed appropriately and in all the other ways that we'll talk about.
All right, thank you. UI?
I would say yes, if and only if the omission of return were also rectified. And I think that's what Mr. Horton was getting at with those other concerns. But
Oh,
if-
yeah, sure. But the question was just about the cutoff concerns. And so it sounds like both companies agree that if the CT bar were to start in rate year one, those cutoff concerns would be addressed.
They would, although
Okay.
I emphasize return to emphasize that that is a severe concern, but to your question.
Thank
yes.
you. And OCC, do you have a perspective on this at this moment?
Sure. I understand the company's concerns. I think the concerns the companies have is called regulatory lag. Like that's the concern. The companies do not want to incur any regulatory lag, it seems. And I understand that. I would also want that if I were a utility. But that I think is what we're talking about. Like that's the gap that Mr. Horton talks about between the demonstrable level of plant at the end of the evidentiary period and the actual level of plant as of, for instance, like the average level of plant in the forward-looking rate year. We agree that those are likely going to be different numbers if the company is building incremental plant. I mean, they have to be. If those two numbers are different, then the revenue and the rate year number is higher, then the company is not getting sufficient revenue to support that plant. But that, as I understand it, in traditional rate making is on purpose. Like the idea of that is to kind of hold that back as a mechanism to ensure that the company isn't overspending or underspending for its allowed revenue requirement. And the company has to kind of incur that drag. And it ultimately is a loss. We understand the company doesn't get to recover the depreciation expense or the associated return or tax expense on those years in which it's not receiving the revenue to support those costs. But again, our perspective is, yep, that's called regulatory lag, and that's a risk factor that, as we understand it, is inherent in the rate making design. And it seems that the perspective that the company should be allowed to contemporaneously recover every single component of the revenue requirement associated with plant as it enters rate base, it eliminates. I'm struggling to locate any risk for the company in the model that's being proposed, and which means that ratepayers are assuming the risk that is currently incurred by the company.
If I might, I love talking about regulatory lag. This was the soapbox that I was mentioning. So, and I totally agree with the sentiment that regulatory lag has an important role. But just as it relates to capital, if we go back in time to 15, 20 years ago, or even longer, and we don't have revenue decoupling, but we have steady, stable sales growth increases of 2 to 3% per year, which was the case for the long duration of utility rate making in the United States of America. Utilities could count on steady, stable growth in customer usage and sales volumes that produced revenue. So in that paradigm, we would have a rate case where we would go into a rate case and we would determine what the going in level of rates would be based on a historical test year, based on known expenses, based on plant additions, et cetera, based on a historical amount. And the regulator in all jurisdictions would then establish a cost of service and develop rates designed to achieve that cost of service. But those rates then in the real world would be applied against actual sales volumes, the actual number of kilowatt hours that customers consume. And here in our region, we could expect to have customers using more as they had more appliances, as they expanded their homes, as new customers came into the service territory, as they were using electricity to a greater extent. And that produced a different level of revenues than what the rates were designed to collect. So if you're in that world, now regulatory lag is a concept that says you have a changing revenue stream that supports your business every year. And as long as you're able to manage your overall pool of expenses under that changing, and at the time for the history of utility operations was steady, stable increases in revenues, now you're in a world where you're not bound to a fixed revenue target that is not going to change because of revenue decoupling. You're bound to a level of revenues that will vary over time and again grow at a tune of 2 to 3% per year. You're not fixed to the cost of service is my point. Your level of revenues that support the business is growing. And so utilities in that world, regulatory lag says, as long as I can control my costs to work under that envelope of revenues, now I'm incentivized to ensure that I'm not spending more than I'm able to on anything, whether it's expenses or on plant additions. It doesn't say that I cannot spend a single dollar, and it doesn't say that the regulatory construct only provides revenue support for specific capital projects that have been placed into service. In fact, it didn't do that at all. It designed rates based on specific capital projects, but the actual revenue support that those rates produced was based on the ultimate sales volumes to customers. The whole paradigm has had to be turned upon its head because customers have successfully deployed behind-the-meter solar that reduces the metered load, or highly successful energy efficiency programs that stop that growth in the customer usage per customer. But yet utilities are continuing to experience increasing cost pressures by having to replace investments that are aged out and need to be replaced, even if we don't have additional sales volumes. Or if we have, increased public pressure to accommodate that behind the meter solar that requires more automation and real-time visibility, we've had to really ramp up our level of investment. All of this would be described in the IDSP. So I completely agree with the sentiment of regulatory lag, but the concept is now different because now we're designing a rate where we're not going to come out of a rate case with a level of rates that will produce some other higher level of revenues. We're going to come out of a rate case that's going to set our level of revenues. If we had more because there's actual sales volume growth as customers use more, or we attract new customers and new businesses to the area, we're going to give that back through revenue decoupling. We will not have any more, we will not have any greater revenues necessarily to support that. Or even if we did, it may not matter because we're still having to make investments in the system that aren't necessarily revenue producing. My point is that the whole idea of regulatory lag needs to be retained in the ultimate PBR model, but we cannot just rely on historical precedent that made sense at a different time. Right now, we know if we come into a case and we set the cost of service based on test year level of actual plant additions and arbitrarily cut off the level of change to the rate year for any component of the cost of service, all we're going to know is that we're going to set a revenue target that doesn't reflect the utilities costs, reasonably reflect the utilities costs that it expects to incur in the rate year. And as it relates to capital, again, I think we're not looking for, I don't agree with the way that it was framed, that we're looking for, perfect cost recovery or guaranteed cost recovery at all, but we're looking for a framework that says that in the rate year, and in any rate year under a PBR framework, that the revenues that are set at a level that will give the utility an opportunity, but not a guarantee, to cover all of its costs of doing business, including capital, expenses, taxes, and everything else, including all of the other, charges that are put on us in REO2 or that are described in the IDSP. If we don't get to that framework in any way, while also retaining the incentive properties to ensure that we're spending as little as possible to do all of those things, and I think we've missed the mark on PBR. And I think we would be doing that if we continue to rely on some of the old precedent that made sense historically, like having cutoffs for capital when we're in a rising capital environment. I think the answer lies somewhere in the middle of looking for a full capital tracker for all expenses so that it is, as Attorney Wheel said, at least the design would be that there is revenue recognition for 100% of additions, which isn't what we're advocating for. Somewhere between that outcome or an outcome that just has arbitrary cutoffs that we know won't result in that level of revenues in the rate year. So I think it's, all I say that to say is all of these concepts, single issue rate making, regulatory lag, they all still have value, but they don't apply uniformly. We really need to look at why they exist, those concepts exist in utility rate making, and is it truly single issue rate making just because we're talking about storms? And I would argue no. Or regulatory lag, to say that, relying on a historical level of plan additions and regulatory lag is a concept that we're trying to throw the baby out with the bathwater is not what we're trying to do. I think we really need to look at how does the framework that we're putting into place still keep in mind those concepts that really have a role to play for customers, but doesn't necessarily, is not germane to the current world that we're operating in today.
I want to give Attorney Wheel a chance to respond if you'd like, and if not, we're going to keep moving on with some CT bar questions.
Sure. I mean, I understand everything Mr. Horton said. I'm not sure I understand where the regulatory lag is in a scenario that he described. Maybe we can talk about it some other time, but if a company is actually recovering, retaining increasing levels of revenue that can support its increasing investments, I get that doesn't stop. I mean, the company still can't spend however much money it wants to, but still not sure I understand how regulatory lag is a factor at all in that scenario. Either way, though, the last thing I wanted to say is I think what we're talking about here is with respect to the CT bar is, it seems to me that what PURA is attempting to do in this straw proposal is to resolve some of the issues that the companies are raising here without removing all discernible risk as I viewed it or said before. My understanding of the CT bar, with the caveat that we also have concerns about it, is that it's an attempt to kind of balance, to give the company some level of increased revenue to support incremental investments, but also maintains some level of risk to require that the company still has to kind of come back in and prove out its case before 100% of those investments enter rate base.
Thank you, Attorney Will.
Could we respond? I don't want to speak for Mr. Hurwitz. I think he also had a quick response. I'll be brief.
Thank you. Briefly, thank you.
Sure. First, generally agree with Attorney Wheel's comments regarding regulatory lag. Second, if I understand Mr. Horton's point about the disconnect between with the cast-off rates, I think it arises from the cast-off rates reflecting capital addition, revenue requirement impact of capital additions based on historical test year. And if that's the case, I don't understand why in a rate case, which is trying to set all of those inputs to go into rates, why the capital piece wouldn't reflect a forecast of rate year capital plant additions, instead of a historical test year that sets up this need for potentially some proxy or artificial mechanism to try to compensate for it. In the rate case, why not just use a forecast of plant additions to set rates? Rate year 2 would use the CT bar, I think, to effectively, as a proxy to accomplish the same thing. That's it. I don't know if you have anything to add.
I'll be as brief as I can. Attorney Wheel would not say that we are trying to eliminate regulatory lag. Rather, I would say that we're trying to ensure the PBR framework that's set here provides the utility with a realistic opportunity to earn its authorized rate of return while delivering the performance that customers expect. I think regulatory lag has been a part of rate plans in the past, but I think if you study those rate plans, as Mr. Horton said, you'll see that they also come with some other mechanism that gives the utility a reasonable chance of delivering that performance expectation. Maybe it's the absence of an RDM, meaning they can retain the benefit of load growth to minimize the effect of regulatory lag. Maybe they get a higher authorized ROE in recognition of the greater risk that they're taking on. Maybe there's a capital tracker specific to cast iron bare steel main replacement, but we look at the PBR framework outlined in this revised straw proposal, and there don't appear to be any such mechanisms available to the utility to mitigate that regulatory lag. It can't be load growth because there's an RDM that guarantees we collect the total approved revenue requirement, no more, no less. It can't be efficiencies because there's already a separate S factor mechanism that designs some level of efficiency into the rate making framework. So we'd have to achieve even more efficiency than is contemplated by PURA at the outset. It can't be underspending in capital because we have to turn around and give that right back to customers. So we look at this totality and say, well, there's not really a pathway for the utility to earn its authorized rate of return. And I think every party to this proceeding has agreed that there should be. So we see that as a problem. Now, that said, I understand very much where you're coming from, and I don't see this PBR plan at all as devoid of risk from the utility. I think there's tons of risk implementing PBR for the first time in a jurisdiction. What if we need to do more emergent capital work? What if more investment is needed to hit our reliability targets than is contemplated by the IDSP? Well, the CT bar mechanism would still have regulatory lag on us getting that increased investment into rates. What if the company needs more FTEs to meet the disconnection PIM in REO2? The utility would have to eat that cost if the costs come above the I minus X minus S threshold. What if PURA missets the S factor? You could go on and on. I think this PBR framework does entail a significant amount of risk, and we're not in any way trying to say that it shouldn't involve risk. In fact, we think that we should be we should be allowed to earn an ROE because we take on risk, but rather we think that it's not risk in this revised straw proposal. It's a guarantee that the utility will not have a fair opportunity to earn its authorized rate of return.
All right, thank you. We're going to keep going with some more questions related to the CT bar, and Mr. White, please.
Thank you. Yeah, I just want to start out with the supplemental for UPA 76 that I had mentioned before, and also this discussion here about starting it in rate year 1 instead of in rate year 2. If you could incorporate that into the supplemental.
You mean discussion as to whether we would support starting the adjustment in rate year 1 versus rate year 2? Or how that would
you could include
affect
that,
the
but
calculation, or just
updating the model basically to include it, what the numbers would be in rate year 1.
I understand.
Okay, thank you.
But I think just so that I'm clear, is that in your estimation, is that what's described in the straw proposal? We just didn't see that concept at all. I did see a footnote that talked about planned and unplanned. I didn't see the concept that the CT bar would start commensurate with rate year 1 rates. And I only say that to say that I just want to, as we're responding, which we want to do, that I think there would need to obviously be additional changes in the way the straw proposal is written.
Okay.
Let's just say that if that's not how you read it, then assume in the supplement that it's saying that rate year 1 is when the CT bar would kick in.
Okay.
Thank you. Okay.
Thank you. Laura, if you could go to, I'm not sure where you are right now, PBR CT bar steps 1 through 5 tab. In row 11, sorry, this is to Eversource. In row 11, it appears to be applying an I minus X factor to the depreciation expense for the years 2027 through 2029. I'm wondering why. And
sorry, go ahead.
Yeah, no, go ahead. Let me keep going. I apologize. Instead of applying the projected I minus X factor in the CT bar submission, would the company have an issue if instead preliminary CT bar amounts were approved that would then be adjusted by the revenue cap formula. In other words, this approach would authorize a CT bar incremental amount that would be netted by the actual revenue cap formula for depreciation on an annual basis.
Not hearing the distinction. I think the difference for your original question, why did we start it in 2027 is because we assumed that the year one revenue requirement is the going in revenue requirement. So for example, on page 19, it's the straw proposal describes what year two revenue requirement is, which is year one plus I plus 1 plus I minus X plus S, Z plus CT. It's not defined in here what is year one revenue requirement then. Going in, somewhere in here, you got to tie going in revenue requirements to all this other stuff. So we interpreted the straw proposal as this formula is essentially effective in year two, meaning PBR begins year two, CT bar begins year two. So in that world, what you're doing is you're backing out that first step. The reason you're inflating or escalating depreciation is because you're identifying how much revenue is already essentially covered by either your going in revenue requirements or their escalation. So you're basically just taking that right off the top, and whatever's left over is the capital you need to support. And we assumed, or we interpreted this as taking effect year two. So that would mean applying inflation for year two, but not one.
Yeah, I'm just, okay, that's good for right now on that. Thank you.
Just to follow up though, is the inflation you're using, is that a projected inflation assumption then?
Here it is, because we don't know what it's going to be at the time, but like the way that we do it in Massachusetts, and similarly the way we presented analysis about the future, you need to use some estimate for what's happening in the future. In this case, it's a GDPPI forecast, but in the actual mechanism itself, when you're talking about the revenues, the rates that do take effect, at that point, you would only be using inflation as published by what we used, which was the Bureau of Economic Analysis. So actual at that point in time. But right now, we don't know what that is. So this is just in lieu of what that number would be.
Okay. So at the time that the adjustment is actually made, that would be done using actual inflation as opposed to the projected inflation.
In terms of how we are interpreting the straw proposal and the way that the PBR mechanism in Massachusetts works. Yeah.
Understood. Thank you.
Yeah, so just one comment on that, just about the Massachusetts, is just to generally keep in mind that the CT bar there's similarities to the K bar, but it is intended to be unique. Like, for the capital, we're looking at the forecast in the IDSP. We're placing a reliance on that, which I don't think that exists in the K bar in Massachusetts, based on my limited understanding of it. Just drawing the distinction that it's two distinct mechanisms.
Yeah, I mean, that's true. That's true. It's a separate track. But I think the intent of the ESMP process in Massachusetts is essentially on the work that the system needs and the level of investment that K-bar needs to support. So it may not be that the ESMP necessarily informs the other, but the work, I guess the result of the work would inform the K-bar.
Just for clarity on that, the ESMP, the acronym, I know I've read it before, but I don't recall it off the top of my head. For the record.
It's the Electric Sector Modernization Plan. I view it as akin to the IDSP.
Got it. Thank you. I'd like to jump over to UI and your model. Um, I'm wondering if you could, Laura, if you could move over to the attachment 2 Excel file. And probably go to the main sheet there. I'm guessing it's the first tab, the CT bar. I'm wondering if UI would be able to walk us through the model and how you did it. I'll just say, like, as an example, one of the things I'm wondering about right off the top, I didn't see, similar to Eversource, I didn't see any distinction between planned and unplanned. And if you could just walk us through some of what you'd put into your model.
Yeah, sure, no problem. And I've got what's up on the screen, up on my screen here, the one CT bar tab, and this was intended to largely follow in the footsteps of the previously submitted Eversource response to UPA 54 with some tweaks layered in as we understood to be appropriate from our reading of the revised draw proposal. That begins with step 1, which is simply a measurement of the capital component of the going in revenue requirement. As shown here, we picked up depreciation and property tax, not return, as we understand that was not contemplated in the revised straw proposal. We also provide another version of this tab that is exactly the same as this with the return line filled in based on our recommendation there. That in this case, those two things, depreciation and property tax, adds up to the going in capital revenue requirement before we gross it up for gross earnings tax, and that results in our total going in capital revenue requirement. Then in step 2, as Eversource was describing earlier, we translate that going in revenue requirement into the capital related revenue requirement implied in each year of the PBR based rate plan in steps 2 and 3. Step 2 is us bringing in the percentages, and subject to check, I think we brought in the actual values of inflation over this particular period. In this particular period, we used UI's 2016 rate case. So these are values from like 16, 17, 18, 19, et cetera. And I think we had bogeys for the X and the S factor. Step 3 translates the dollars in step 1 and the percentages in step 2 into dollars in each of the rate years. And then step 4 is where the meat of the CT bar calculation takes effect. First, step 4A calculates the what I'll call sum total of CT bar related rate base activity. So we have our first line is additions, and I'll talk more about that in a second to get to your point, Mr. White. Then we have cost of removal, retirements, and ADIT. And for all 3 of those inputs, cost of removal, retirements, and ADIT, we just used a very simplifying assumption for purposes of this that those things would be based on a ratio to plant additions. With respect to plant additions specifically, we added this tab 2, capital additions. This is a bogey, but it shows our under tab 2 capital addition shows our understanding that the CT bar mechanism contemplates 2 different types of capital, one linked to IDSP and another that is everything else. As a practical matter, we don't have an integrated distribution system plan yet. So what we did for purposes of making numbers into other numbers for this response is we took the Schedule F7 filed by UI in the 2016 rate case and just arbitrarily bifurcated that between IDSP and non-IDSP. We fully anticipate that requiring further exploration over the course of this proceeding and REO3, but that's what we did for this. So 4A calculates what I call the sum total of CT bar related rate base activity. Step 4B then turns that activity into rate base. You can see we have a column for March 31st, 2017, which is based on our recreation of the revised draw proposal when the evidentiary record in that case would have ended. Then we have a 3-month jump to the beginning of rate year 1, because in that case, based on the current litigation period for rate cases, rate year 1 would have begun July 1st, 2017. And then each column thereafter reflects an extra 12 months of activity. And we do a lot of math for the different piece parts of rate base, but it all brings you to numbered line 46, Excel row 55, which is the ending CT bar rate base. And then in step 4C, we translate that ending CT bar rate base into a revenue requirement. And finally, in step 5, we bring it all together where we compare that CT bar revenue requirement to the capital related revenue requirement implied by I minus X minus S and provide the incremental capital funding in each year. And we must have been clairvoyant because to the point of your questions from earlier, we have included what that capital funding would be in rate year 1. To Eversource's point from earlier, the baseline revenue requirement to which that is being compared is not escalated for I minus X minus S, but the baseline mechanic of this calculation is what is your CT bar revenue requirement and what are you getting without that adjustment? So it's just math to compare those two things, and that's what we've done here.
Thank you. Any questions for anybody on? Okay.
That's good. Question.
Oh,
Just
yeah.
one clarifying question. Thanks, Mr. Horowitz. For the additions shown here, see from, say, June 30th, 2017, and then the subsequent rate years, does that reflect the company's actual plant additions over that time?
This does not. This reflects, we imputed what plant additions would be based on a just what I'll call very high level estimate of what it would have been had we tried to do this method at the time of last case. And I know all of these years are now in the past, but we tried to put ourselves in the shoes of, imagine when we were preparing the case, we wouldn't have actuals. What would we have guessed plant additions to be? So this is not actuals, but rather that guess.
Okay, thanks.
I have a question. I guess it's for both companies. Do the companies foresee when they're providing the plant predicted through the IDSP, the dollar figures for each of those? I mean, the straw proposal talks about providing the plant for rate years 1 through 4. Are those like in present dollar? Is the company, when the company is calculating its forecasted plant needs, is it not adjusting for inflation or productivity in those numbers?
And we got ourselves all kind of twisted around on that question. And you can see on our 2 capital additions tab, we have all kinds of inflation adjustments intended to get at just that. I candidly don't know without having an IDSP in hand what exactly that would entail. If you're getting at potential double counting between inflation as it's baked into the capital plan and inflation as it's baked into the I minus X escalation, I think that is accounted for in here in that step 5 that I described. We compare what is the overall level of revenue support necessary to support the plant additions coming out of the CT bar and compare it to the overall level of revenue support provided without this incremental capital funding mechanism, and that includes consideration of the I factor. So that potential double counting of inflation is avoided in that way. But to your question as to what role do we see inflation what role do we see inflation playing in the IDSP process? I'm not sure sitting here today.
Yeah, the reason I asked is that I didn't interpret the STAR proposal to be proposing that the I minus X be applied to the CT bar, but I see that both companies do. I'm just trying to wrap my head around, I mean, like as most people in the room know, the calculation of plant is the actual value of the plant at the time that it enters service. So I've always assumed that, like, for instance, historically in rate cases here in Connecticut, when a company is asking for a forecasted plant, it's calculating that forecasted plant in the future using the assumed value of at that time, like if it's $1 million asset at the time it enters service, that's the time it's worth $1 million in the future, not $1 million now before it exists. So I'm just trying to wrap my head around the rationale for applying I minus X if we're accounting for forecasted plant, like using that methodology.
And maybe I expressed it poorly, or maybe my colleagues at Eversource have a more artful way of saying this, but I would not say that we are applying I minus X to the CT bar. I can see why you would reach that conclusion because this is an Excel file calculating CT bar and there are lines for I minus X in it. But I would not say that's what we're doing. Rather, I would say that we are calculating the CT bar revenue requirement without respect to inflation. We make some inflation adjustments here because we were trying to calculate a historical average and reflect inflation that in that way. But broadly, as I think your question implies, we would expect the CT bar mechanism to say, this is the level of plant investment we expect the company to make in each rate year. And then without inflation adjustment, you take that information and compute the revenue requirement. For us, where I minus X enters into the equation is kind of to the point of a comment you made earlier. We want to avoid double counting. So we're saying this is the overall CT bar revenue requirement that if the utility is going to invest at the level of the IDSP and, you know, the way we're going to measure non-IDSP investments, this is the revenue requirement it would need. How much less than that are the rates it's collecting without this adjustment? And the rates it's collecting without this adjustment does include an I minus X minus S adjustment. And so for that reason, we compare the total CT bar mechanism without an I minus X adjustment to the overall capital revenue requirement with an I minus X adjustment to avoid that potential double counting.
I get it now. Thank you.
From our standpoint, I would say the IDSP, as far as the forecasted capital, whatever goes into that, whether it's inflation or system, whatever goes into those needs is a separate thing altogether from the revenue requirement. But where I minus X influences CT bar is it's actually outlined in literally in step 3, where you're basically taking depreciation from the prior year that's already reflected in the revenue cap formula, and you're inflating it by these other factors that are included in that same formula. So so I guess in that sense, the I minus X is essentially giving you revenue based on whatever your depreciation was in the prior year. And that's how it influences, I guess, that CT bar.
Got it. Thank you.
Ms. Freyer, I saw you reach for the mic earlier. Do you want to add something?
I think it was resolved. I was making a comment earlier not to confuse the difference between revenue requirement versus capital additions. But I think everything is clear now between everyone.
Very good.
Thank you. Staying with UI, Laura, if you could switch tabs to, I believe it's tab 2, capital additions. Yeah. So within there, and I forgot to write down the rows. I can't see it that well, but the question is, where did the company derive the 90% for the IDSP and the 10% for the non-IDSP?
That was our bogey.
Got
We
it.
just took the schedule F7 from the last case and
Okay.
like I said, we weren't 100% sure about planned versus unplanned, what
Sure.
contemplated to fall within the IDSP versus not. And we didn't want to not provide something in light of that uncertainty. So we just assumed that 90% of what we put into schedule F7 and docket number 160604 would fit as IDSP, and the remainder was non-IDSP.
Okay, thank you.
And obviously, there's a lot of science on this tab that would change depending on the answer to that question. I think the important part of this attachment is we're trying to show our understanding of the mechanics of the CT bar calculation. And to that point, you know, how you get there matters and is something I anticipate talking about more as REO3 evolves. But the only part of this tab 2, capital additions, that carries forward to the remainder of the model is the final one, numbered line 26, Excel row 36, which shows the total of IDSP and non-IDSP plant additions that we're reflecting. So maybe we get to that total in a different way as we get more understanding about IDSP, but that's what was the important takeaway from this tab in our view.
And so my understanding right now is that my hope is that the two EDCs will have some conversations about how to define the unplanned and update those numbers. That's what I intended to talk about before.
I'm always happy to talk with Doug. And we can certainly update. I think I would say again, the timing of that update, I think we'd benefit from having seen the revised draw proposal in REO3 to make those comments as educated as possible.
And what is the date on?
Friday.
Okay. Okay.
Maybe before we adjourn, we can talk about the timing of the supplement, just to make
Thank
sure
you.
that's clear before we leave.
Yeah, thank you for that. And so, what, again, to UI, I think this is back to the other tab we'd been on before. Why did the company include plant additions and retirements in step 4?
As I mentioned in my opening spiel, first 4A is intended to capture all of the rate-based related activity that flows from plant additions. There are a lot of elements of rate base, but not all of them are plant related. But the ones that are plant additions, accumulated depreciation, and ADIT, and retirements are something that affect both plant additions and accumulated depreciation, and accordingly, we've reflected them here. Further, while I understand that that the CT bar is a unique mechanism, it's not the same as the K bar. As I mentioned in my introduction of this Excel file, we began with Eversource's response to UPA 54, which I understand mimics the approach used in Massachusetts. So I think our inclusion of retirements in this analysis would therefore be consistent with how, not the same, but similar style incremental capital funding mechanisms have been reflected in other PBR jurisdictions.
Thank you. That's it for me except for the supplemental.
Okay. I have a question regarding the CT bar calculation for OCC and CIEC. And it's regarding the fifth step, the final step before, well, the penultimate step. So before the CT bar revenue is calculated, step 5 is described in the SROT proposal as reviewing the results from step 4 to make any required adjustments to account for other factors such as elimination of capital additions that are recovered in separate mechanisms, or the elimination of non-essential capital additions, including capital additions that could be delayed. And my question for OCC and CIEC is, this would be happening in a rate case, and is that the appropriate point before the final calculation in step 6? Would that be an appropriate place for non-company parties to challenge based on their review, or discuss various aspects that are being included versus maybe delayed or excluded from the K-bar?
Hi, Tom Wheel from OCC again. I assume I'm still supposed to introduce myself every time I talk. Yeah, it makes sense to me that there's a space in the rate case to make sure that everyone has a chance to talk about that. Again, like our concerns about double recovery, what I think of it as like crossover double recovery, because it's not necessarily like, our concern isn't that like we're going to be 100% recovering the total cost of one investment in 2 different places. It's more kind of like where the lines blur between them. So our concern, we're primarily concerned with, maybe it's a more appropriate concern to raise in REO3 when we talk about like what exactly the IDSP is structured like. The only other thing I want to add is that it's not clear that the interplay between the CT bar and a tracking mechanism. I think, I guess this conversation would also happen in the rate case, but we just want to emphasize our concern that there can also be that kind of crossover if a tracking mechanism isn't really distinctly, really specifically defined, to make sure that there's a really solid, there's a wall between sort of what's in and what's out. Because when that wall starts to blur, our concern is that it's going to blur directly into the CT bar. But so with the understanding that a tracker can't be created or adjusted somehow outside of that same conversation, I understand that this would be a rate case would be the appropriate place to kind of hash all that out.
So with apologies, would you repeat the question? Because I think I generally agree with the answer about the rate case, but want to make sure I'm actually being responsive.
Certainly. So the question is referring to step 5 in the CT bar calculation methodology that was proposed in the revised straw proposal, and states that this is the point where we would review results from step 4 to make any required adjustments to account for other factors, such as the elimination of capital additions that are recovered in separate mechanisms, or the elimination of non-essential capital additions, including any capital additions that can be delayed. And so my question was whether step 5 in a rate case, applied in a rate case, before the final CT bar revenue requirement amount is determined, if that is the appropriate place to challenge the capital additions, the projects, the sort of component parts of what would ultimately become the revenue requirement.
I think so, with the caveat that I assume that the earlier steps, parties, OCC, CIC, other parties will still have an opportunity for discovery, or to the extent they have positions on how those steps are conducted, we still have an opportunity to advance those positions. But if to the question of, is that the step where you'd actually be challenging the issue or not, I think that seems reasonable. If I could just respond briefly to Attorney Wheel, I understand his concern about, agree with the concern about avoiding double counting, and that it's more likely to be, perhaps at the gray areas, some overlap as opposed to 100%. Concern would also apply with respect to the tracking mechanism, except just, as you're aware from our comments, we do not agree with the use of capital trackers in addition to the other mechanisms. We think that the CT bar and we step back. We think that the PBR, the MRP, with the revenue cap formula as described without the tracking mechanism should be adequate. And that if there is some large additional capital project that needs to be considered, it should be considered within the context of those capital budgets, and not just another large cost that's added on to everything else, which, is going to be a challenge for energy affordability, trying to contain costs. Anyway, just wanted to add in that brief response to Mr. Attorney Will also. Thank you.
All right, very good. Okay, then we are coming to the close of, I think, what we can accomplish. We had projected a 4:30 conclusion time for our meeting today. We do have another technical meeting scheduled for next Monday, April 7th, where we can continue to discuss the remaining multi-year rate plan items that we did not get to today, can pick up further discussion on the CT bar if needed, and also the remaining mechanisms that we did not discuss today, the ESM, the RDM, and the CapEx OpEx equalization measures. So with that, if we can just have 1 minute to confer with Mr. White about the a requested due date for the supplement, and we'll settle that, commissioners, before we adjourn. So just 1 minute, please.
Thank you. So I just wanted to recap the request for the supplemental. Adding capital additions for rate year 1, adjusting planned and unplanned to the extent that you can, based on the definition that you have, not based on the IDSP straw proposal on Friday. Another thing I'd like to ask about is removing retirements, additions, and as well as the I-X portions in there. And then specific to UI, your CT bar was done on a monthly basis or done on an annual basis instead of a monthly basis. And if that's an adjustment you could make as well.
Do you want to? Oh, you mentioned something about removing retirements, additions, and I minus X. What did
Yeah.
you mean?
Oh, okay, so the I minus X, that would be the depreciation up near the top of the model that you had created. And then retirements and additions. So actually, this probably applies to the two companies differently. UI had included retirements, additions. Step 4, I think it was put in, so just pull those out of there. I apologize that was not.
So on the first one, you're saying to remove the depreciation, so step 3.
So the idea basically is that the rev cap formula on the depreciation would be done like on an annual basis. So it doesn't get, you're not baking it in sort of as a forecast and then getting trued up later. It's just, we would do one true up via the annual update for the depreciation expense.
Mr. White, I want to provide what you're seeking, but you're losing me. I'm sorry. I don't know that we could do this calculation. Could you just further describe what you're seeking?
Yeah. The comment was specific. I was thinking I had Eversources. I apologize for this, mixing the two of you together. It was directly in relation to what I was thinking about in the model that Eversource put into UPA 76, where you had. Laura, do you happen to have that? If you could pull up UPA 76 attachment 1 for Eversource.
And step 3, right?
So if you scroll up to the top, row 11, I minus X, just taking that out. And I don't recall if UI had it similarly modeled.
We also escalated depreciation.
Okay, so then just take that out. Yeah.
So just to confirm, so step 3, the way that it's outlined in the proposal says to take depreciation and account for how it's escalated through the revenue cap formula. You're saying don't do that.
The idea is that it would be incorporated in the revenue cap formula during the annual.
Next year.
Yeah.
Okay.
Yeah. I think that's what I'm thinking, what you just said. Yeah.
Okay. I think I get it.
Okay.
I think we just shipped it out.
Complicated. I totally understand. Okay.
I think if we can get in the next couple minutes, just the clarity on the request for the supplement, we'll move forward with that approach. But we just had a moment to discuss whether an interrogatory would be a more appropriate way to get those changes. But let's try, just for in the sake of time and getting to advancing the conversation for the next technical meeting. Again, commissioners, if that's all right with you, let's just take a couple more minutes to see if we can work that out. And if not, we can use an interrogatory to try to be more precise with specifically the modifications for a supplement.
Could we stick with depreciation for a second, just to make sure I
Please.
follow? So is your view that the amount of depreciation, and I've got Eversources up on my screen as it is up here, that the Excel row 29 depreciation already included in the revenue cap formula would be the same for the first 4 years and then the same for the next 4 years when presumably it gets reset? Or meaning I minus X never enters the equation at all? Or rather, would the escalation occur on a lag relative to what's here? I just want to make sure we do what you're seeking.
Say that one more time. I apologize.
So let's say we create the supplement you're envisioning.
Okay.
In that supplement, are the depreciation numbers the same for 4 years in a row. In other words, using these numbers here, would it be 259 in cell G29, 259 again in cell H29, 259 a third time in I29, and then 249 a fourth time J29? Or would you escalate it by I minus X at some point in that chain?
The former,
The first one?
yes.
All right, I understand. And we can discuss the merits of that, but I understand.
Thank you.
Then to make sure I'm following planned versus unplanned, we're deliberately delinking that from IDSP. It's just what we see as planned versus unplanned.
Yes, and I think the reason for that would be obviously the straw proposal for the integrated distribution system plan docket is not out yet. And I think understanding the company's proposal there and understanding of what is emergent versus not would be very helpful as well.
I gotcha. And then when talking about the retirements change, you said a lot of words. Is your vision just that retirements are not part of this analysis, but otherwise it remains unchanged? Or are you envisioning other things go away as well?
I think it was what was in step 4, retirements, replacement cost. Or cost, yeah,
You're talking cost of removal?
cost removal, yeah.
So simply remove retirements and cost of removal from the analysis?
Yes,
I understand.
thank you.
Can I have one clarifying question? And then, so the revenues that you said the plant additions start in rate year 1. Do the revenues as well? For CT bar, do they take effect the same day as the going in revenue requirements, or are you talking just the plant additions start on the same day?
Well, I don't quite understand the question. To me, they would both be starting on day 1. Rate year 1, day 1.
Okay, yeah, that's my question. So
Okay.
CT bar would start the same day. The revenues would take effect the same day as going in revenue requirements.
Yes.
Okay.
Yeah.
Can I just ask, I know we're trying to get out of here, but the depreciation piece, I'm a little lost on what we're trying to do with that or what the objective is of that by fixing it, what the impact is in terms of, I guess, the theory. What we're trying to do is reflect that you're going to have a level of depreciation expense in base rates. Base rates are going to be adjusted by the I minus X. So the amount of depreciation revenue support in base rates is changing. So I could be mistaken, but I think by not doing the way that we've done what we've done with the depreciation and applying the I minus X to it, I am concerned we're creating the potential double up that Attorney Wheel has been flagging, where we would have revenue support for depreciation expense and base rates. The CT bar would be calculated ignoring that. And I think you'd potentially be creating that concern unless I'm missing what the actual impact is of making that mathematical adjustment.
In the supplement, I think we're interested in getting to a place for the use of actuals. And that could be done annually, looking at truing up those annuals versus what was projected in the case of the analysis here.
I'm lost.
Okay.
Maybe we could do the supplement. I mean, because I don't quite understand, you're saying replace actuals. So you're saying that in the straw proposal, the vision of the straw proposal was that the depreciation expense reflected in the CT bar calculation would be actual depreciation expense per book or something?
I think that let me think about that for one moment. And then we can maybe go to an interactory.
Yeah,
Can I take a
because
shot?
we wouldn't know actuals obviously now, we would derive that later. So I think for that reason, we would just hold it constant now without the actual information available to us.
So are you picturing that when we file for rates for the CT bar, let's say in rate year 4. In that year's calculation, we would use actual depreciation from rate year 3 per books. Like we would know that number. So in that case, there's no need to inflate it. It would just be last year's actual. That's the part we back out of the CT bar calculation.
That's what we'd like to see in the supplement, yes.
So then I think on row 29, what you would want to see is not an escalation or a flat 259, flat depreciation. I think what you'd want to see is the theoretical per books in the cost of service. So instead of 259, you would see, or I'm sorry, so instead of 265 and H29, you would see whatever is the actual depreciation that we've got in that model per books.
Yes, I think that makes sense.
Without the inflation. Yep.
Yes.
Okay.
Would that be in row 29 then, or is a different step, right?
I think I'm sorry, I don't get it. Like a big
All right.
classic
I
big,
think-
like I just don't get it.
I understand why you don't get it, Mr. Horton, because we're talking a little abstract about these numbers. And I think the best thing to do would be to, if the companies can provide a supplement by, if possible, this Friday with your understanding now, and we could follow up with an interrogatory if we need to understand some different scenarios. I think that might be the most efficacious way to go forward.
Or, I mean, I would hate to bog everybody down with another technical session, but the rate wonks, I would absolutely love to, like, if we could pick each other's brains, because it's, what we're talking about, I'm worried, is not what we read in the straw proposal, and it seems like it's a material change that would impact the incentive properties that we understood we were trying to get to as being different from the K-bar, but for the CT bar. And I don't want to just throw numbers at the page. Of course, you don't want us to either. Like, we can do math, but what's the math standing for?
Yeah.
And that's what I worry about. So I think what I'm comfortable doing based on what we talked about is breaking out planned versus unplanned as we define it and working with our, colleagues to try to do that. And then I'll take a fresh look at what the straw proposal said about planned and unplanned in that footnote that we didn't distinguish in our initial draft. We can talk about having the CT bar go into effect on rate year 1 and the potential simplicity that would introduce from our minds around the certain cutoffs that we had talked about, but I'm not comfortable making an adjustment on depreciation or retirements or cost of removal for that matter without understanding what else we're trying to do, bigger picture.
Okay, for that reason, thank you for pointing that out. For that reason, let's leave cost of removal and depreciation as is in your models and make those 2 other changes for the supplement, please. Starting in rate year 1 and also planned and unplanned. And Kit, is it possible to have those supplements filed by 4 p.m. on Friday?
We can certainly try.
Okay.
Also, let me compliment your vocabulary. You used penultimate and efficacious. Very impressive. What I was going to also offer, like Mr. Horton, I had some question marks about those other things, but we could try to write a few words around what we were thinking when we did those things our way, if that would be helpful. Just to,
yeah, that would be helpful, please. But we'll leave the supplement to those 2 points, and if we need further clarification, we can always go through interrogatories.
I understand.
Okay, thank you. Eversource, does that make sense? Are we good to move forward with a supplement for 4 p.m. with those 2 changes on Friday, please?
To break out planned and unplanned, and then to describe how, and to model how having the K-bar go into effect on rate year 1 would change versus what we had filed. We were just talking about, we've identified some differences between how the 2 companies interpreted the straw proposal. So by Friday? Yes.
Okay, thank you. Appreciate that. And thank you everyone for sticking with us through that discussion.
Just one last reminder for UI about breaking it out as monthly versus yearly. If you could do that by Friday, if you can't.
Is there something in particular that you're hoping to get at with that? Because we can add some values by month, but it's just going to be more high level assumptions.
Okay. If you could do that, that would be helpful. Yeah.
Is there a particular period in which you're most interested in seeing the months, or?
No, not right. Not off the top of my head.
Okay.
Thank you.
All right, with that, I think we're done for the day, commissioners, so turn it back to you.
Yep. Thanks, everyone. I thought today was a great conversation. We'll see some of you back on Wednesday for REO2 and see this group back next Monday, the 7th. Commissioner Karen, any closing? No? All right. Have a good evening.